Further hearing in the appeal, continuing on the application of J.S. Sri Lanka against the Secretary of State for the Home Department.
Right, you've got the right things.
It's just the separate part it's disappeared.
Oh, right. Yes, Mr. Ike.
My Lord, I'm grateful. My Lord, yesterday I took your Lordships to the international instruments drawn up to make provision in respect of crimes against humanity and war crimes and the case law on joint criminal enterprise. And that showed, we submit, that a person may be liable for such crime where the following criteria are fulfilled. One, and I will take that just to set the scene for Gurung, if I may, my Lord. One, that he is part of a group of persons, such as an organisation. Two, there is in existence what is referred to as a common plan, designed or purpose, which involves the commission of the crime.
Sorry, common plan?
Common plan, design or purpose, which involves the commission of a crime. Though that common plan, design or purpose does not have to have been previously arranged or formulated, it may be inferred from the fact that a group of persons acted in unison to put into effect such a common purpose. And three, that he participates in the common plan, design or purpose, though such participation does not need to involve the commission of a specific crime, but may take the form of assistance in or contribution to the execution of the common plan or purpose.
May take the form of what?
May take the form of assistance in or contribution to the execution of the common plan or purpose. And while the courts have held that the participation in the joint criminal enterprise must be significant, that is, so as to render the enterprise efficient or effective, or enable the system to run smoothly.
I mean, if you're dictating this, that's one thing.
No, my Lord,
I see. I mean, do you want us to take, you don't want us to take this down?
Are we going to find this in Gurung?
My Lord, no. What I'm trying to distill is the principles of the case law I took your Lordships to yesterday in order to make it shorter to go to Gurung. So if I slow down, would that help?
Would it be helpful to have it on a piece of paper?
My Lord,
yes.
I apologise, I haven't put it on a piece of paper, and I'm more than happy to do so.
I think what we're really searching for is a formula which we can take from you, and then when Mr. Singh addresses, we can see whether it stands up to examination.
My Lord, yes. Shall I go through it again?
Yes, I think it would help.
More slowly,
really, we should have it word for word if that's what you're wanting us to understand.
My Lord, I'm grateful. So,
And this is going to be your end submission as to what we are to look at.
my Lord, yes.
But I mean, we're never going to get into the refinements of these things in a case like this, are we?
My Lord, no, but what I have to address in my respectful submission is...
For example, there's a possibility of a sort of spontaneous plan.
My Lord, yes.
Now, that may or may not have happened. You're not going to show that.
No, my Lord.
No. I mean, all we're concerned with is a broad, surely it can only be a rather broad thing. I mean, this may be ultimately what, if you had a trial, you would be going into in detail and so on. But at this stage, you can't surely.
No, my Lord, but what I'm seeking to show, and if that, of course, that is at the core of our submission, the Court of Appeal found that the Secretary of State applied the wrong test, and the respondent says the Secretary of State applied in part the wrong test because they misunderstood international criminal law, which is why I was trying to draw out the principles we get out of international criminal law on joint criminal enterprise, which then leads to the same principles being applied by the Canadian and the German case law I took your Lordships to yesterday in the refugee context, to then show that Gurung really just builds on that in order to make the same point again, and that there was and is a common international consensus that that is the appropriate approach. The reason I've gone into this much detail is mainly in a sense to meet the challenge. Our case is that this is a judicial review on which the Secretary of State, the question is, has the Secretary of State applied the right test? And our submission is, in the broad line, he has. That is why I sought to set it out in the way I have. If that is...
Well, I think you better go over the points again, but I must say the points you're making so far seem to me to have been put very succinctly by the German court in and don't look it up, please, 1073, paragraph 21, where they say there must be active support. He must have been personally responsible in some way, such as making a substantial contribution to the commission of the crime in the knowledge that his or her act or omission would facilitate the criminal conduct. I mean, that's encapsulating all your points, I think, in a neat sentence.
But Lord, it does, yes.
It's 1073, I can't give the name because it doesn't have a name, paragraph 21. And this is where they
1070.
paragraph 21.
It's not 1073.
It's 1073, and
No,
it struck me that it was a very neat
My Lord, yes.
drawing together of these points.
Paragraph, sorry, what?
Paragraph 21.
21.
I hope I'm right in saying.
No,
It's 73.
no, it's not 73. It's less than something else.
German case.
Yes, it's not happened. It's 70 something else.
My Lord, is this the case at 75?
I beg your pardon,
Federal Administrative
75.
Court?
And it certainly appears paragraph 21,
Yes, I see.
where you see this, it's a fairly short paragraph, paragraph 21. The sentence, thus the person seeking protection need not have committed the serious crime himself, but he must be personally responsible for it. And then you see the phrase, either committed personally, which we're not dealing with in this case, or made a substantial contribution to its commission in the knowledge that his or her act or omission would facilitate the criminal conduct. Now, one can add the word substantial, which you've drawn in, and this is all based on paragraph 18, as we see. It's a very neat formula.
My Lord, I apologise if I've over-elaborated, but that's exactly the point I was making, which is, it comes back to, that is the German court applying in the refugee context what we say can be drawn from the material I showed your lordships in Cassese and others, from the criminal law. The two run hand in hand. They apply the same principles, though in a different context, of course. One is a criminal trial which leads to a sentence and a punishment. The other is a status determination which goes to the mere question, if I can put it like that, whether there are serious reasons for considering that he is responsible for such a crime.
Yes.
And of course that paragraph also then deals with the other point I wanted to re-emphasise, is that of course that approach has now been, we say, kind of enshrined in the legislation in Article 12.3 of the directive, which that paragraph 21 is interpreting.
Indeed, yes.
The otherwise participate in the commission of the crime.
But I mean, isn't the correctness of 21 essentially the subject of the reference to the European Court of Justice?
My Lord, it is, but no, it is not, my Lord. What is the subject of the reference to the European Court of Justice is the prior question whether membership of the organisation, coupled with membership of an organisation which is listed, so in that case, the establishment coupled with the support, but the core is, which we have here, because the Court of Appeal accepted that war crimes have been committed and crimes against humanity have been committed, that first question, which is in our respectful submission at the core of the question, is there. Of course, you don't have that. There, the whole purpose is, there, the core of the question is it enough for them to be listed in the EU list? Coupled with, and that again it deals with our submission about the presumption of the rebuttable presumption, coupled with active support for the organisation's armed struggle, but it isn't focused at the common purpose in that sense.
It strikes me it isn't actually directed at the key words from our point of view, which is what is meant by the words instigate or otherwise participate in, which is what Article 12 is talking about. It's not really directed to the latter part so much, and I'm not very confident one would get much guidance from the European Court of Justice on the point we're really looking at.
No, my Lord, that's why we put...
From that question.
My Lord, yes, it is focused very much on the interpretation of 12.2b and c, and not the question we're addressing here, which is why we set out in our printed case that while your lordships need to be aware of these references, we don't anticipate that much guidance will arise in relation to the question your lordships are concerned with from this reference. What, of course, may arise is that if this question is answered in a particular way, irrespective of what your lordships say in relation to 12.2a and 12.3, it may mean that he falls to be considered under, this respondent falls to be considered under 12.2b or c in light of the ruling of the Court of Justice.
Well, I'm afraid I've rather interrupted you on, we all have on,
My Lord,
on your list. Is there anything left on the list that you would want to put forward, or are you
No,
content
no,
to
my
take
Lord,
the
I think
formulation?
that effectively deals with the with the core test I was seeking to draw out of the two lines of jurisprudence I sought to show your lordship yesterday, the international criminal law and the international refugee law jurisprudence, and wanted to then really take your lordships to Gurung, if I may, and that is at volume 1, tab 11. And your lordships will see there in paragraph 2 of the determination what the IAT was seeking to do in what is acknowledged by all the jurisprudence, what is a very kind of fact-sensitive area. It was seeking to give guidance to adjudicators on the proper approach to the Refugee Convention's exclusion clauses, all three of them under 1F, particularly as the events of the 11th September 2001 have made the need for clarity of approach imperative. And they then list in paragraph 3 the material and authorities they have looked at. So it's been a fairly exhaustive consideration both of the international learning on this matter, together with the proposed directive, the proposed qualification directive at UK court and tribunal decisions listed in footnotes 1 and 2, as well as case law from Canada, the Netherlands, New Zealand, the United States, and a very recent Australian High Court judgment. The tribunal then sets out the background to the case, but in relation to the principle, we then find in paragraphs 32 to 36, the tribunal acknowledging, one, in paragraph 32, that this is, of course, not to be interpreted according to national law criteria, but according to an international law perspective which seeks to give an autonomous meaning to the acts and crimes specified. It then records a reminder by Lord in paragraph 33, a reminder from Lord Mustell in the House of Lords decision in T, that even though the wording of Article 1F has not changed, the world around it has. In the aftermath of the events of the 11th September, these thoughtful words remind us that whilst there's nothing new about criminality, the precise forms and methods used by those who perpetrate violent acts or crime continue to undergo change. And then it's also recording in 34 that not only has the world changed, but the law dealing with such crimes has as well, and then refers to the case law of the ICTY and the developing international criminal and international human rights law on the subject. There's then the reminder of the well-settled principle that the Convention is a living instrument in Article 35, and none of that is contentious. And then in 36, a statement that it has to be the Convention, or Article 1F, will almost always have to be applied restrictively. And we would just point out at this point that the tribunal in KK, which your lordships have at tab 14, but I don't ask your lordships to turn up, reminds, at paragraph 62 onwards, makes clear that what the tribunal there meant was interpreted restrictively rather than applied restrictively. And that is also reflected in paragraph 149 of the UNHCR handbook, to which the tribunal in paragraph 36 makes express reference.
What was the paragraph number of KK again?
The reference to
62 to
62.
67, my lord.
Yeah, thank you.
We then, in passing, the tribunal in paragraph 95 sets out its reasoning in relation to the standard of proof, which your lordships have asked me to left over to reply if necessary, and we then come to the core of the determination, really at paragraph 102 through to paragraph 113. And your lordships will see the tribunal there saying, in certain cases, at 102, at page 24, in certain cases raising Article 1F issues, an adjudicator will be confronted with someone who has acted on his own, having committed, for example, an ordinary serious crime such as murder. However, in many cases involving exclusion issues, an adjudicator will be faced with evidence that an individual is a member of an organisation committed to armed struggle or the use of violence as a means to achieve its political goals. To take typical examples, the appellant may have been a member of the PKK in Turkey, the LTTE in Sri Lanka, the FLN or GIA in Algeria, or, as in the instant case of CPN, Maoist in Nepal. Or he may be linked to a multinational organisation vowing armed struggle, such as Al-Qaeda. How relevant is it that sometimes armed struggle organisation abandon violent methods or enter into peace agreement which result in the cessation of a violent struggle, in contrast with the adjudicator's task under the inclusion clauses, where the test is one of current risk? The exclusion clauses, under the exclusion clauses, what is required is a historic inquiry. Hence, the fact that since the appellant left his country of origin, his organisation no longer pursues armed struggle will not be relevant to whether he did commit prescribed acts or crimes before he left, nor will it be relevant that, as the tribunal noted in Thaya Baron, an appellant has become a reformed character. But in such cases, the question arises, is mere membership at the time of the commission of acts or crimes prescribed by Article 1F enough to entitle an adjudicator to conclude an appellant is excluded under this provision? The tribunal has consistently stated that mere membership of such organisation is not enough to bring an appellant within the exclusion clauses. In the light of the previous case law and the further material now before us, we would highlight two further principles that should be borne in mind when considering complicity. So that's recognition of the first principle we identified throughout the case law, both criminal law and refugee law, that membership alone is not enough. The first of the principles is set out in paragraph 105. It would be wrong to say that an appellant only came within the exclusion clauses if the evidence established that he has personally participated in acts contrary to the provisions of Article 1F. If the organisation is one or has become one whose aims, methods and activities are predominantly terrorist in character, very little more will be necessary. We agree in this regard with the formulation given to this issue by UNHCR in their post-September 11th document at paragraph 18, where, however, there is sufficient proof that an asylum seeker belongs to an extremist international terrorist group, such as those involved in the 11th September attacks, voluntary membership could be presumed to amount to personal and knowing participation, or at least acquiescence amounting to complicity in the crimes in question. In asylum procedures, a rebuttable presumption of individual liability could be introduced to handle such cases. Drawing up lists of international terrorists at the international level would facilitate the application of this procedural device, since such certification would carry considerable weight. Now, just pausing there, of course, the Court of Appeal criticised Gurung in 105 for saying it is very little more will be necessary, and not indicating what that little more is. But in our respectful submission, both the quote from UNHCR and the passage I will take your lordship to in 108 makes clear that they do set out what further is necessary in their second principle. But just going on with the citation from Gurung at 106, that complicity in this type of case should be sufficient to bring an appellant within the exclusion clauses is necessary in order to adequately reflect the realities of modern-day terrorism. The terrorist acts of key operatives are often possible only by virtue of the infrastructure of support provided by other members who themselves undertake no violent actions, and then refers to the interpretation of, amongst other things, the convention in McMullen, where the court notes, the US Court of Appeal Ninth Circuit notes in the last sentence, in our judgment, the only reasonable interpretation of the exception is that it encompasses those who provide the latter with the physical, logistical support that enables modern terrorist groups to operate. And of course that again reflects what how Cassese summarised the rationale behind the international criminal case law I took your lordships to. There's then the reference in 107 to the previous tribunal decision in Oza, when considering the appeal of a person who had voluntarily joined and supported DEFSOL, which with reference to objective country materials on Turkey was described as then being an illegal party dedicated to violence, then it is no use his asserting that he does not support its policy or methods. If he does not endorse the central policy of the party, he should not be a member of it. In any event, his membership and contribution to the life of the party is indirect support for its violence acts. So it's again, taking back also to the circumstances of this case, it's voluntary, knowing, continued membership of the organisation. And then in 108, the tribunal does, in our respectful submission, set out what else is necessary in its other principle, its second principle. And it says the other principle to be borne in mind is that whilst complicity may arise indirectly, it remains essential in all cases to establish that the appellant has been a voluntary member of such an organisation who fully understands its aims, methods and activities, including any plans it has made to carry out acts contrary to Article 1F. Thus, for example, it would be wrong to regard the mere fact that an appellant has provided a safe house for LTTE combatants as sufficient evidence that he has committed an excludable offence. If, however, he has transported explosives for LTTE combatants in circumstances where he must have shown that they were to be used for what they were to be used for, there may well be a serious 1F issue. And again, we say that is the important additional criterion that is necessary, voluntary, knowing participation in the activities of the organisation. And then in 109, we would also observe that international criminal law and international humanitarian law, which in our view should be the principal sources of reference in dealing with such issues, as complicity adopt similar, although more detailed criteria in respect of those who, for the purpose of facilitating an international crime, aid, abet, or otherwise assist in its commission or its attempted commission, including providing the means for its commission, see Article 25 of the ICC statutes and Article 7.1 of the ICTY statute, as analysed in Tadic. Of course, such reference will need to bear in mind the lower standard of proof applicable in the exclusion clauses. And we respectfully submit that's of course right. The reason international criminal law needs to be more detailed in its approach and more detailed in its approach is one, that it has to deal with these matters to a very different standard of proof, and it of course leads to punishment and not merely to status determination. The tribunal goes on, however, as the passage just cited from UNHCR highlights, even when complicity is established, the assessment under Article 1F must take into account not only evidence about the status and level of the person in the organisation, and factors such as duress and self-defence against superior orders, as well as the availability of a moral choice. It must also encompass evidence about the nature of the organisation and the nature of the society in which it operates. Such evidence will need to include the extent to which the organisation is fragmented.
Is the reference to the passage a reference back to paragraph 105?
That's what I understand, my lord. It's a reference back to paragraph 18 of the addressing security concerns.
And is the quotation from paragraph 18 there complete?
My lord, your lordships have, I will check, your lordships have that document at, on a quick look, my lord, it does look at it as if it is complete. Your lordships have the full document for your lordships' note at volume 15 at tab 115. And I think the way they reach that is by reference to the last sentence of that quote, namely the fragmentation of the organisation.
Yeah.
Which, of course, we have in the LTTE later on, after, I think, 2004, when the Karuna faction took its own course.
So it's really the last sentence of paragraph 18, the position in the organisation, and so on.
My Lord, yes, voluntariness of his or her membership, as well as the fragmentation of certain groups, would need to be taken into account.
Thank you.
And again, of course, that we would respectfully submit reflects overall our six-factor approach, which I outlined to your lordships yesterday morning.
So what do they mean by self-defence against superior orders? What's that?
My Lord, what I understand that to be a reference to is what is reflected in the Canadian case law, is whether by resisting an order he would put himself in effect in a higher danger than the victims of the act are being exposed to, and therefore whether he has the ability through his position within the organisation, whether it is actually truly voluntary in the sense that he has through the position in the organisation the ability to resist the order to undertake a certain act. And we then come in paragraph 1111, we see that the tribunal comes back to, having analysed the past tribunal cases, to what it sees, we respectfully submit, as its primary role, namely to give guidance to adjudicators and now immigration judges, and notes their failure to, at times, take the contextual approach, and therefore set out the continuum which the Court of Appeal has criticised as an aid for the adjudicators and, in a sense, the decision-maker to address the factors that are relevant in order to answer all the questions that are raised by Article 1F. And on that basis, the tribunal suggests, on the one end of the continuum, let us postulate an organisation that has very significant support amongst the population and has developed political aims and objectives covering political, social, economic and cultural issues. Its long-term aims embrace a parliamentary democratic mode of government and safeguarding of basic human rights. But it has, in a limited way and for a limited period, created an armed struggle wing in response to atrocities committed by a dictatorial government. In such a case, an adjudicator should be extremely slow to conclude that an appellant's mere membership of such an organisation raises any real issue under Article 1F, unless there's evidence that the armed actions of this organisation are not in fact proportionate acts which qualify as non-political crimes under 1FB, so not really concerned with 1FA at all. And then in 113, at the other end of this continuum, let us postulate an organisation which has little or no political agenda, or which, if it did originally have genuine political aims and objectives, has increasingly come to focus on terrorism as a modus operandi. Its recruitment policy, its structure and strategy has become almost entirely devoted to the execution of terrorist acts, which are seen as a way of winning the war against the enemy, even if the chosen targets are primarily civilians. Let us further suppose that this type of government, such an organisation, promotes its authoritarian in character and abhors the identification by international human rights law of certain fundamental human rights. In the case of such an organisation, any individual who has knowingly joined such an organisation will have difficulty in establishing he or she is not complicit in the acts of such an organisation. And of course, again, it's the tribunal recognising will have difficulty, which it creates a presumption, but it leaves it open that on the individual facts, it may well be possible that an individual is not covered. What the tribunal is seeking to do here is just give practical guidance to the decision makers as to how to approach the evidence they may be confronted with in order to address the questions posed and the questions we've identified as posed by Article 1F.
Are you commending that paragraph 113?
My Lord, it is not a distinct part of the test, my Lord. No, I'm commending it in a sense as a reminder to the tribunal that this is a very fact-sensitive exercise and it's not a tick box exercise, and therefore what you need to look at is look at where in that spectrum the organisation fits, and then look at the other questions about personal involvement, how were you recruited, was your membership
Why does the fact, I mean, this is just asking the question I think Lord Walker asked yesterday, I mean, why does the fact that it's got authoritarian aims, the type of government, why does that lead you more readily to conclude that somebody is complicit in the acts, the terrorist acts of the organisation?
My Lord, to the historic analysis, the future aim of the organisation is, I would accept, of very limited value. What I think, in my respectful submission, what the tribunal was seeking to do was portray the two very extreme ends of what they see as a continuum of the various terrorist organisations and other organisations, immigration judges and tribunals and decision makers are confronted with on a daily basis. Ultimately, to the decision as to whether the organisation, whether membership of an organisation leads to exclusion, the government a revolutionary movement envisages, I accept, is of very limited value indeed.
Do you accept the criticism of the Court of Appeal in paragraph 114? This is in the core volume, page 31. You'll recall that Lord Justice Toulson is critical of a continuing approach, and he says that, to take it shortly, paragraph 114 at the bottom of page 31, that it takes the decision-maker's eye off the really critical questions, whether the evidence provides serious reasons for considering the applicant to have committed the actus reus of an international crime.
My Lord, if these two paragraphs, 112 and 113, were to stand alone, that may be justifiable. But in my respectful submission, the tribunal has set out very clearly in 105 through to, 104 through to 110, that what the principles are and what the questions are that need to be asked. In my respectful submission, 112 and 113, it adds another cautionary mechanism in order to prevent adjudicators being either too ready to exclude people under 1FA or to dismiss arguments under 1FA, but to focus on what is in relation to an organisation, an essential factual inquiry. But isn't the end of the inquiry. It's only the inquiry that goes to factor one of the list of factors I outlined yesterday.
I think there are two basic criticisms which I've picked up. There may be more, but the first one is the phrase "very little more is required" in paragraph 105. Yes. And then there's a continuum approach. Yes. I think Lord Justice Toulson accepts much of the other material, which is fairly securely based on other sources. But it's these two things at either end of the guidance, which he is indicating really weaken the protection, as it were, for the applicant. If you're told very little more is required, which is a phrase one's come across in other cases, then that's a pretty good encouragement not to look too deeply into the case. And then you're told, well, there's a continuum approach, and you look at the organisation and so on rather more closely than what the individual did. And that's another criticism.
My Lord, yes, but that's why our respectful answer to the two criticisms, the criticism on 105 is answered by the passages in 108 onwards, namely that the little more that is necessary is showing voluntary membership and full understanding of the common purpose. And what in 112 through to 113 the continuum approach is meant to be, in our respectful submission, is having observed failings in previous approach to it, is to, in relation to factor one as I've identified it, namely the nature of the organisation, is to remind the decision maker and the adjudicators that this is a highly fact-sensitive inquiry and that there is a range of organisations that will come before them, and that there may be, and that is only the starting point of the analysis, and only in the most extreme case could you assume that no real issue under 1F is raised, and in the other very extreme end, very little more would be necessary, always leaving open, of course, the requirement set out in 108, namely the need to establish voluntary membership and knowledge, as we put it, a full understanding of the purposes.
What was particularly unhappy about Cartha Pillai? We got that case? Or?
My Lord, no,
Paragraph
we don't.
Well, in a sentence, do you happen to know? I mean, because it was an unhappy example of an approach. I mean, that's why they thought it helpful to look at a continuum. But do we know what went wrong with that case?
My Lord, I don't.
Okay, well, could somebody just send it to us in the fullness of time?
My Lord, yes.
Yeah.
Yes.
My Lord, and that's really the passages in Gurung I wanted to take your Lordships to, and the answers we give in relation to the criticism that's been posed.
Is there any case in this country, or indeed around the world, that has specifically focused on the intelligence division of the LTTE?
My Lord, not that we have.
Okay. Thank you.
That we have seen.
I was struck at tab 8. We've got one that hasn't been referred to yet. Senior immigration judge Freeman and others, but in paragraphs 25 and 26 at the end of that judgment, he does actually talk about real known organisations. You know, and it strikes me that is actually much more helpful if one's trying to give some guidance to tribunals up and down the country than talking in the generalities. Do you see it? That's the passage in which he refers to an ordinary shooting war in the north of Sri Lanka. That is actually addressing the practicalities of the problem.
My Lord, yes, it is, of course, but why that is addressed to a particular problem, the problem that he was confronted with and the group he was confronted with. But of course, what the tribunal in Gurung sought to do was effectively give guidance which would help on any organisation that might come before a decision maker, be it the LTTE, be it the PKK, Al Qaeda, and the number of.
It's hard to think of what organisations would match the two imaginary examples in 112 and 113. And some possibly would say that the African National Congress would be within 112, but I don't want to raise new subjects for discussion there.
My Lord, yes. What that amounted to, in my respect, is a hypothetical extreme without necessarily without referencing it to a specific example which is current or past. But of course, the past jurisprudence may well have encompassed exclusion under 1FA in relation to South African nationals who were members of the African National Congress, or even German war criminals. As we know, the American case law, for example, is largely built around excluding war criminals from the Second World War. And just in terms of the ordinary shooting war, of course, I took your Lordships yesterday to the factual circumstances of this case and the role the appellant played as second in command to the person who was in charge of the intelligence unit's operations in Colombo.
Yes.
Could you perhaps, just to highlight this point, refer to the bits in the Statement of Facts and Issues on which you particularly rely? You've accepted, I think, that we're looking at events after September, or on or after September 2000, when he was 18.
After his 18th birthday.
So we don't need to trouble with the earlier events, but are there particular bits that you rely on, and if so, which are they and why?
My Lord, effectively, in relation to the Statement of Facts, it is. It starts at paragraph 3. Around the time of his 18th birthday, the respondent was appointed to lead a mobile unit of the Intelligence Division responsible for transporting military equipment and members of the Intelligence Division by foot from Vanni through jungles to settlements close to Vanuatu, from where the members of the Intelligence Division were sent to Colombo wearing civilian dress. He continued to doing this job until April 2002. There was an informal ceasefire between the LTTE and the Sri Lankan government from December 2001, and the agreement was signed in February 2002. So during the course of, again, coming back to some of the examples in the case, from the date of his 18th birthday through an official ceasefire, he helped transport both military equipment, and we saw what the German court made of the individual who transported German equipment and ammunition, and members of the intelligence division into Colombo wearing civilian dress. And again, the evidence we have in the War Crimes Report shows what the intelligence division was up to, in part, in Colombo throughout the LTT's operation. We also do rely on the fact that he was one of the chief security guards of Potu Aman, the head of the intelligence division, at paragraph 4, and that therefore he was instrumental, or he was one of the people who were there in order to prevent, amongst other things, Potu Aman being apprehended and brought to justice. And of course, Potu Aman is somebody who, being reportedly responsible, amongst other things, for the assassination of Rajiv Gandhi, who is wanted internationally by an international arrest warrant. It is those matters which we rely on. And then at paragraph 5, early July 2002, he resumed responsibility for the supply of military equipment to plainclothes intelligence division members. And then from 2004 to 2006, served as second in command of the combat unit of the intelligence division. It is those factors we rely on, and I took your lordship partly because that's where your lordship's inquiry in the fact started in the CEF, as to the detail he gives at, I think, page 142 and 143, about who he was second in command to, in effect. And of course, the individuals he was guiding into government territory and he was supplying military equipment for were members of the LTTE who were in civilian clothes undertaking activities, which of course in itself is potentially a war crime insofar as they were engaged in attacks.
Is there anything to be taken from the first sentence of paragraph 6? And here he is actually going.
My lord, yes, that in a sense is the culmination of it. It is unexplained what he was meant to do there, but he went on instruction of his superior. And was sent to Colombo to await further instructions. We have no evidence, the Secretary of State has no evidence what he was meant to do there, but he was a member of the intelligence division who was sent to Colombo to await further instructions. And of course, as we see there, he went not as a combatant, but he went in plain clothes to take up residence with a local family and to take up a job, but with the instructions to await further instructions. And again, in light of what the LTTE did in Colombo in those days, one may be able to draw inferences, but there's no further evidence than that.
But he was anxious to avoid suspicion, suggests
Lord,
that he
yes.
was still a member of the intelligence division at the time.
My lord, yes. And
Well,
of
he
course-
went under a false name. I mean, he
Yeah.
was entirely incognito. The people who were putting him up didn't know he was anything to do with the LTTE
Yes,
at
right.
all, and he was wearing a different name and civilian clothes.
Yes, my lord. But he also wasn't apparently there for, to call it that, espionage purposes, because what he did was work in a video rental, as I recall.
Sorry,
What he did was, his job was in a video rental, as I recall. So there's no evidence that he was undertaking intelligence work in that sense, i.e. working as a spy, but it is unexplained what further instructions he was to receive. But he was plainly concerned about being incognito and not being recognised. And at page 143 of the CEF, he makes clear that he is worried that he would be persecuted by the LTTE because, being a member of the intelligence division, he might have given away their secrets.
Well, we've passed 10:30.
My lord,
so
yes.
I don't know how much more you feel you need cover.
My lord, all I really need to cover, and perhaps I can give your lordships this by way of paragraphs to read rather than, because I'm very conscious that I've taken longer than I was allocated. What I wanted to take your lordships to, and your lordships is the UNHCR material, and your lordships have seen paragraph 18 referred to in Gurung. The other document is at volume 15, tab 116, and that is, in a sense, from the UNHCR point of view, the most important document setting out the test, and it makes that clear in paragraph 2 what it has taken into account and what it has drawn on for the benefit of the of drawing up that note. And then could I just ask your lordship perhaps to look at...
What date is this document?
This document is, it shows on page 2 at the bottom, my lord, 4th September 2003. But we will also see that in the letter UNHCR wrote to the parties on the occasion of this appeal, that it reasserted that that is the guiding document for UNHCR's position in relation to 1FA.
Where's the letter?
The letter, my lord, is
I know
at
it's
page,
December.
paragraph 121, the last document in that tab,
This is the December letter, is it?
the 8th December 2009 letter, my lord.
Where is it? Oh, yeah, God.
Small date, just under the UK.
Yeah.
But in the document 116, could I ask your lordships to note paragraphs 23 through to 25, which sets out the breadth of international instruments that are relevant to this consideration.
Which paragraph, sorry?
23, my lord, to 25, page 8 through to page 10.
Yes.
And then paragraph 51 through to 55, which deals with individual responsibility and draws on the case law of the ICTY, which some of which we have looked at. However, without having seen the appellate decision in Krasnich, which of course makes clear that the contribution needs to be significant but not substantial, and then paragraph 59 through to 62, pages 23 and 24, where your lordships will see at footnote 60, paragraph 60, a reference to Ramirez, and at paragraph 61, footnote 61, an adoption of the approach in Gurung. And then, your lordships, in the letter of the 8th of December, it's the paragraph running across pages 1 and 2, so starting at 1, UNHCR's authoritative interpretation, to the end of that paragraph at page 2, and then pages 4 through to 6 under the heading Personal Involvement in Underlying Act.
This
This is the letter. This is the letter at the
The
back.
letter, paragraph 121, my lord.
Yes.
And your lordships will see from the footnotes, all of this refers back to the background note, which I just showed you, lordship, at tab 116.
So, as far as 121 is concerned, you asked us to look at pages 1 and 2.
1 and 2, and then pages 4 to the top of page 6, my lord, and then only the concluding paragraph on page 7.
Yes.
And my lord, we would respectfully submit, as we did in our printed case, that of course the Court of Appeals approach is inconsistent with the approach adopted by UNHCR throughout, building on that international case law. Two other references, if I may. Bundles 11, 12 and 13 provide Canadian, New Zealand and Australian and US cases, which I won't take your lordship to, but they all develop this issue further, with the exception of the XY case in New Zealand. And at volume 15, tab 111, we would commend to your lordships the article by Joseph Rykoff in the 2006 Journal of International Criminal Justice, which again draws the two competing strands together. And our submission would be that the 6 factors I identified yesterday morning were to provide a checklist to ensure that the decision maker asks the right questions in order to obtain the information that is necessary to answer the questions raised, and whether there are serious reasons for considering that an individual is responsible for a war crime or a crime against humanity, an approach approved by the Canadian Federal Court in the case of Escorcia, volume 11, tab 78. And that the Secretary of State, in his decision letter, and the War Crimes Unit report applied that test, and in our respectful submission, the Court of Appeal was wrong to conclude that the test applied was wrong in law, and that the factual conclusions reached by the Secretary of State on the evidence available are not such that applying a judicial review test, they fall to be quashed. And as a result, we would ask your lordships to allow this appeal and, in effect, restore the decision of the Secretary of State. My lord, I apologise for the overrunning, but those are the submissions on behalf of the Secretary of State.
Thank you very much. Mr. Dillon.
I'm sure Mr. Hyde will be pleased to hear nothing further.
Thank you very much indeed. Mr. Singh.
Can I begin by reminding us of the structure of the Court of Appeal's judgment?
No, I think your speaker has been switched off, and you'll need to speak up a little bit. You're rather at the limb of the bar.
If it helps. Lords, can I begin with the Court of Appeal's judgment? Not to look at it at this juncture, at least, in great detail, but just to remind this Court of the structure of the judgment and the decision under appeal. And what it is actually that the Court of Appeal decided in this particular case. It begins in the appendix at page 3, but I'd like to begin, if I may, at page 28 of the appendix, where the judgment of Lord Justice Toulson begins to analyse what he called general principles. Much of this has already been seen, and I know has been read with care. But what I'd like to remind the Court of is that after considering the general principles, as it were, at a more abstract level, at page 33, Lord Justice Toulson turned at paragraph 123 to apply those principles to the present case. And he concluded that the Secretary of State had failed to address the critical questions in accordance with the general principles he had just set out. It's a classic case of judicial review where the executive is found by a court of law to have misdirected itself as to the correct legal questions it has to ask itself.
So he's directing his attention to the last few paragraphs of the decision letter.
Yes.
And seeing what's put into these paragraphs and see whether they measure up to the principles.
Exactly. Not, I respectfully submit, prejudging what the conclusion of the executive would be if it directed itself correctly in accordance with the law. That is, of course, classically the function of the court on a claim for judicial review. And one sees the consequence in remedial terms at paragraph 124, where he concluded, I would quash the Secretary of State's decision that the claimant was excluded. And that was done classically on the ground of judicial review of misdirection, or, if one prefers to put it this way, a failure to ask the right legal question. It is not an irrationality basis for quashing. In this case, in some cases it might be, in principle, but it's not the basis on which the Court of Appeal quashed this decision. Classically, and in accordance with conventional public law principles, I would suggest the Court that does not preempt what the outcome would be of a correct decision-making process in accordance with law.
So you're saying that while we can obviously look at the statement of facts and
Yes.
issues and may draw conclusions from that, that isn't really the point in this case.
It's not. My Lord, that's right. And I would respectfully, and I want to, if I may in a moment, to go back to the decision letter itself, because that is certainly the reasons which the respondent, as he now is, was given as to founding the Secretary of State's adverse decision against him. And if that was, on classic judicial review principles, flawed by a misdirection of law, then, in my respectful submission, the decision of the Court of Appeal quashing the decision should be upheld. If, conversely, Lord Justice Toulson was wrong as to the general principles of law, if, conversely, there was no misdirection of law, then the decision of the Court of Appeal will be reversed. And again, it's not really, in my respectful submission, relevant or necessary to delve into the underlying facts, because that's the executive's decision, and there it is. If he hasn't misdirected himself in law, there's nothing for a court then to do. My Lords, may I then turn, I will come back to the Court of Appeal judgment for the general principles in due course, but may I at this juncture remind the Court of the decision letter under review. And your Lordships have that in the appendix towards the end, beginning at page 528. First, may I remind the Court that paragraph 7 on 529 is summarised what the nature of the claim and the grounds was before the Secretary of State. There was the claim for asylum, as we've already seen, but there was also a claim for humanitarian protection. And this too, and in my respectful submission, some sight has been lost of this later on in the decision letter, face a real risk of the death penalty or execution and unlawful killing, and torture or inhuman or degrading treatment or punishment in the country of return. Now, although in terms that doesn't refer to Article 3 of the ECHR, it is in substance surely a reference to that. And of course, there is no exception, there is no exclusion clause to Article 3. That, we surmise, is why, in the result, discretionary leave is granted at the end of this decision letter.
Well, I got the impression yesterday, I may have misunderstood it, Mr. Ike was saying that we needn't trouble about humanitarian protection in this case for that reason.
Well, Lord,
but you're saying perhaps we ought to look at that.
No, my Lord, what I would respectfully suggest is that one may have to bear in mind the distinction between humanitarian protection, to which the exclusion clause does apply, under government policy and now under the EU directive, and the completely discretionary leave which was granted in this case. And as we surmise, it's not entirely clear on the papers before the court what the basis was for granting discretionary leave, but I would apprehend that that had to be granted because there was this claim being made under the Human Rights Act. It wasn't just a claim under the Refugee Convention or under the policy on humanitarian protection. So the first two of those are disposed of by saying you don't qualify because you're excluded under 1FA, but then you find right at the end of the decision letter that in fact you qualify for discretionary leave. That's paragraph 37
yes.
on page 5. I'm surmising, but I hope it's a reasonable inference to draw, that must have been because the claim based on the absolute provision referred to in paragraph 7 was implicitly at least being accepted.
I mean, certainly, if these recurrent 6 months leaves stop and you maintain there's a real risk of Article 2/3 mistreatment on return, well, then that will give you a fresh challenge. That's the point. But we don't have to deal with that.
No, exactly.
I mean, now that we're many 6 months down the road, assuming you fail on this appeal, I mean, what's then the position in terms of an appeal?
There's no right of appeal in relation to the decision which was taken in 2007. For that, there was only this application for
Right.
judicial review.
Yes,
But
right.
if the Court of Appeal's judgment is upheld,
Yeah.
in other words, in law, the decision of September 2007 is a nullity, it does not exist, that would have to be retaken. And because now of the passage of time, I apprehend that, and certainly I would want to argue for my client, that he would have a right of appeal.
Sorry, that's if this appeal succeeds.
Forgive me, my lord, I'm taking it too quickly. If your lordships uphold the Court of Appeal's decision,
Yeah.
quashing the executive's decision, the legal result will be that there is a nullity there. It has to be retaken. It would have to be retaken in the light of circumstances at the time of the decision. And because now my client has had an aggregate of more than 12 months
Quite.
discretionary leave, Section 83 of the 2002 Act, which we can provide copies of to the court if you wish to see it, my lord. I don't know if it's helpful. If my lord would like to see it, I know the clerk to the court has
Well,
copies.
we've seen it before. Is that the one that has a list of decisions that are
That's Section
appealable?
82, my lord.
Oh,
And then
82
Section
is-
83, it may be helpful if perhaps we can just have a very quick look at it, if you wouldn't mind, just to clarify this procedural
82
point.
is the list and 83 is the grounds.
No, my lord. 83 is the exclusion, which means that my client in 2007 could not appeal.
Right.
And that's why this is a case by way of judicial review. And in that, your lordships will see that the
Oh, I see.
contents of the 2002
Yes.
Act are given for reference. And then Malone Jr. has helpfully copied some of the material provisions.
Yes.
But particularly, I would invite attention to page 41, forgive me, it's section 82,
Yes.
page 48 of the copy. Section 82 begins at the bottom. That's what I think my lord has in mind
That's
as the
right.
kind of decisions which can be appealed.
That's right. Yeah.
And then your lordship will see importantly that in our case, that there was no right of appeal because of section 83. This section applies where a person has made an asylum claim. That claim has been rejected, but he is being granted leave to enter or remain in the UK for a period of exceeding 1 year, or for periods exceeding 1 year in aggregate. The person may appeal to an adjudicator against the rejection of the asylum claim. The implication being that if it's less than 12 months at the relevant time, which it was,
Yes.
then no appeal. That's why the courts found themselves having to grapple with this claim for judicial review.
But you don't acquire, you say under 83, you don't acquire sort of retrospectively a right of appeal by being granted successive periods of 6 months after the decision was taken.
Well, my lord, can I put it this way? I certainly wouldn't want to prejudice my client. If your lordship-
On the face of it, you do.
Exactly. Well, my lord, that's why it's very important that we're here. But
All right.
if your lordships were
Well, I'm going to write down, if the Court of Appeal is reversed, it may be
It may
under
be.
section 83 that by now a right of appeal has arisen.
It may be.
Yeah.
What I would respectfully suggest is that if it arises, that would arise in relation to the new decision,
Oh, yes.
which would ex hypothesi have to be taken by the Secretary of State.
No, but that's
because-
if the Court of Appeal is upheld.
Yeah.
Yes, I'm sorry.
That's if it's
That's
upheld.
if it's upheld. What I've just read out or written down is if the Court of Appeal is reversed,
I'm so sorry, my lord.
it may be that under 83 by now there's a right of appeal
Yes,
accrued.
my lord, your lordship is right to
Either way.
record that I would certainly want to protect my client's position in that.
Well, we don't have to decide. I
don't have to
just
decide.
wanted to know what the overall position was.
Well,
Thank you.
that's helpful.
Thank
my
you.
lord.
Thank you.
Well, going back to the terms of the decision letter,
Yes.
another point I would wish to make with respect is that under the heading at page 533, which says final considerations, at paragraph 38, it is true that the decision letter says, in the light of all the evidence available, it has been concluded that you have not established a well-founded fear of persecution and that you do not qualify for asylum. But in my respectful submission, that has to be read in the context of the letter as a whole.
It's just formulaic.
It's formulaic, and it's a conclusion. It's not a statement of reasons. The only reason given for leading to that conclusion
Yes, it's a 1F point.
is the 1FA point.
Yes.
And I would respectfully invite the court to take the view, whatever happens to the Court of Appeal judgment, that that's the structure of the decision letter.
Yes.
Now, going back, therefore, to see how did they approach the 1FA question, the critical paragraphs, as my Lord observed yesterday, are really paragraphs 31 to 36.
Well, they are the ones that the Court of Appeal set out. All
Exactly, sir. My Lord, and we invite attention particularly to paragraphs 34 and 35 and how they're formulated. 34 is a direction of law, self-direction of law by the Secretary of State, that Gurung is correct and is to be followed. And note how it's put. It's a very short sub-clause of a sentence citing Gurung, in which it is determined that voluntary membership of an extremist group, even the words international terrorist have now gone, because they were actually in the quotation from paragraph 18 of the UNHCR paper that we read a moment ago, could be presumed to, the words are not rebuttably presumed, which is what the UNHCR was saying, but now it says could be presumed to amount to personal and knowing participation. Now, there would be problems in my respectful submission if that were meant to be a formulation of joint criminal enterprise in the detailed way that Mr. Iker has sought to suggest the Secretary of State was directing herself at that time. There would be problems even if one stopped there, but it gets worse in my respectful submission, because the sentence then continues, or at least acquiescence, amounting to complicity in the crimes in question. In my respectful submission, in a nutshell, what this case is about is that Lord Justice Toulson was absolutely right, that if the nature of the exercise which the executive has to perform is to ask itself what are the elements in law of the crime which is said to be the relevant crime for Article 1 FA purposes, it does not even begin to set out in correct terms the actus reus and the mens rea which would be required for joint criminal enterprise. Now, my lords, it's important that one cannot then just, as it were, brush under the carpet paragraph 34, because it's a crucial element in the reasoning leading to the conclusion here. Note the word which begins paragraph 35. Accordingly. So it's not that at paragraph 35 they're moving on to consider, as it were, what Mr. Iker described yesterday as his category 2. They clearly, at this stage, envisaged in their own minds that 35 is integrally connected to what they've just said at 34. In other words, it's the nature of the organisation. Look at Gurung. There's a presumption which can arise. And I will come back to look at Gurung in more detail, of course, and look at Lord Justice Toulson's criticisms of it. But, my Lord, before I leave the decision letter, I want just to make this fundamental submission, if I may. Although the executive in this case was obviously not conducting a criminal trial, and although there may not, or there may be an issue in this appeal about the appropriate standard of proof, may I leave that to one side for now. In my submission, it is important to distinguish the legal concept of the mode of trial, the standard of proof, which are not issues in this case, from the substantive elements in law of the crime said to have been committed. Now, the last of those concepts, the substantive elements in law of the crime said to have been committed, do have to be asked and answered by the executive, because Article 1 FA compels an answer to those questions. And it won't do with respect to say, well, it may be a hard question. Because first you have to ask the right legal question. Then you'll have to analyse the evidence such as it is before you and see whether the answer is in favour or against the individual concerned. Can I give, I hope it's helpful, I don't know, can I give a more homely example perhaps that might arise or might not? In a local authority context, I suppose it could arise in a very humdrum administrative context. Suppose it's housing improvement grants or something of that sort. And a local authority has the discretion, or it may be the duty, if certain conditions are satisfied, to grant a member of the public a housing improvement grant. But there's an exclusion from this. The policy or the legislation in question also provides, but you shall be excluded from this grant if you have committed theft. Now, although the local committed theft. Now, in my respectful submission, that necessarily compels a public authority, an executive body, not a court of law, let alone a criminal court. It must ask itself the right questions as to what the elements of the offence of theft are. And it has to go about answering them in a fair way and a rational way. But before it goes about answering the questions, it has to ask itself the right questions. And it's well known in this jurisdiction that members of the public can easily be forgiven for not realising that as a matter of law, one of the essential ingredients of the offence of theft is an intention permanently to deprive someone of property, because people often think, who are not lawyers, that if you, quote, borrow, unquote, something over the weekend, that will constitute theft. Now, suppose, it's a hypothetical case, but suppose a local authority in my scenario had just misunderstood, failed to ask itself the correct legal questions as to what are the ingredients of the offence in question. In my respectful submission, the analysis adopted by Lord Justice Toulson in this case would be the same analysis. It would inherently follow that without preempting the ultimate outcome of what the evidence actually amounted to, that there had been a misdirection of law and the decision felt to be quashed. In my respectful submission, this is that kind of case.
Are you going to say that there are 2 points, perhaps? One is that in paragraph 34, the decision taker misapplies Gurung, but in any event, Gurung itself is weak because, and indeed it's its own fault in a sense, because there are passages in it which tend to invite that kind of misunderstanding.
I do say that, my Lord, and it's essentially what Lord Justice Toulson was saying. And I will come back to look at Gurung, and your Lordship has already referred to the 2 essential criticisms that the Court of Appeal made of Gurung, which, as you put it, I think, bookend the relevant passage at paragraph 105 of Gurung, and then the passage at paragraph 111 to 113.
So between the bookends, there's some good bits, but it's the other.
And there's actually, as will have become apparent at this hearing, I anticipate, there's a lot of common ground as to the correct legal principles if we were correctly analysing the actus reus and the mens rea. There's not complete unanimity between us, but my learned friend has been through a lot of the cases that we cite in our printed case, Tadic and so on, the principles of personal culpability, of individual criminal responsibility, albeit that can arise, of course it can, by virtue of a joint criminal enterprise. But the importance of the elements of knowledge and intention, in a sense, I am going to submit to this court that a very useful summary of the relevant principles of international criminal law can be found in the statute of the ICC, particularly Article 25, which is to do with modes of liability, taken with Article 30, which is to do with what they call mental element, we would tend to call the mens rea.
It's really a kind of explanatory, it's almost a sort of definition provision,
exactly.
Isn't it, Article 30?
Exactly so, my Lord. Now, what I apprehend Lord Justice Toulson was really saying in the Court of Appeal judgment was not that Gurung is fundamentally wrong, but that there are dangers in passages in it which take the decision-maker's eye off the ball, off the correct ball. Now, if those are dangers, then what harm is done, with respect, in just setting it out in an easily understood, easily, well, not necessarily easily applicable way, but at least an easily understood way. And I will invite this court to endorse what Lord Justice Toulson does, particularly at paragraph 119, but it's not just there, of the Court of Appeal judgment, there's the paragraphs which lead up to that. In essence, what Lord Justice Toulson attempts to do, we submit successfully did, is to do what Mr. Iker has attempted to do this morning, which is to formulate the principles in international criminal law of modes of liability. Now, as I say, I will come back to his formulation and suggest that it doesn't quite get it right. But that isn't my fundamental submission at present. My fundamental submission is that this court will look in vain at the terms of the decision letter in this case, which he seeks to uphold, for any analysis of that sort. There's no...
You've actually got to show the Secretary of State plainly got it wrong. Well, got it wrong. I mean, the word plainly may be superfluous.
Oh, my Lord...
Haven't you got to show he got it wrong? This isn't a reasons challenge.
No, it's
Couldn't
not.
possibly be. I mean, you've got to show he materially misdirected himself.
Yes.
I mean, what happens if we took the view that he couldn't, looking at the indisputable facts here, have decided other than that there were serious reasons for considering...
Well, in most respects,
On the right-
that
on
would
the
not be an appropriate course for the court to take. Well, for two
Why
reasons.
not?
For two reasons. One is that that's not, in fact, the conventional judicial review approach, because the remedy of quashing, without preempting the outcome, if there was a correct
There
direction...
was a massive authority for saying if we conclude that the only
The
proper
court, certainly,
decision...
the court has a discretion. Of course it does. Of course it does. But that's not the starting point. The norm would be that the executive must get the law right. And the second reason, my Lord, is this. And I wanted to come back to this, and I hope I'll be forgiven if I return to it in more detail at the end of my submissions when I deal with the facts. But the facts that my learned friend has been citing are potentially in dispute. The statement from the report from the War Crimes Unit, which he has been quite happily citing from, was never put to my client before the decision was taken. The only reasons that are mentioned in the decision letter why he is excluded under 1FA are the reasons that you have just seen in paragraphs 31 to 36 of the decision letter. It doesn't even refer to the War Crimes Unit report.
No, but I mean, there's quite a lot in the letter about the basis of the...
There's paragraph 30, my Lord, in fairness. It's basically dealing with a publicly available document, the country of origin report.
Sorry, paragraph what?
Paragraph 30 of the decision letter.
Yeah, but there's also about, paragraph 15, sort of specifying what he did and so forth.
All that stuff.
Yes?
Well, not all the rest of it. I mean, what he was doing.
Well, my Lord, if I have to deal with that, in my respectful submission, it certainly cannot be said the only reasonable outcome, even if there were a correct direction of law, is that he qualifies with a 1FA. As my Lord Walker observed yesterday, certainly much of the evidence, and it came from the respondent himself, of course, and it was largely said to be a credible account.
I didn't find it a very clear match between what he was saying, written down in manuscript, and some of the material in the statement of facts and issues. But you've agreed the statement of
Yes,
facts
we
and issues,
did.
so we can take that as common ground.
But we didn't agree the War Crimes Unit report.
No.
And that was only produced for the first time in the Court of Appeal after permission to claim judicial review had been granted. And my client then did a supplementary statement responding to that. And I'm not inviting the court to accept everything that he's necessarily said. What I am saying is that it's not usually the function of the court to decide those questions of fact. It's for the executive to decide questions of fact fairly and reasonably. But the first stage is to get the law right, ask yourself the right questions.
Is there an issue of proportionality here? I mean, I hesitate to raise that point, but I did notice it came, the word appeared in the United Nations guidance.
It did.
I mean, that of course is an issue for the decision taker if he applies his mind to the issue.
Yes.
But in a case where I suppose it would come in if one's looking at somebody of relatively low status in an organisation as compared with a senior commander? That would be something that would bear on proportionality.
It might well do. Well, I am, when I come to the general principles of criminal law which operate, I am going to suggest with respect that it's not helpful to talk about proportionality, just as it's not helpful to talk about the continuum and the nature of the organisation and the authoritarian purposes and so on, because, again, with respect, it takes away the eye, potentially, from the critical questions of criminal law, which are what are the actus reus and what are the mens rea requirements. And I do emphasise that that's in the context of an administrative law act, and I gave the humdrum example of the local authority improvement grant to show how it can arise. And it's not enough. I'm sorry.
If I looked at the, this proportionality thing struck me when I saw it as well. If you look back at some of these, the cases in the military tribunal from Germany and so on,
Yes.
then they point out that although, or maybe some of the articles point out that, of course, although they concluded on the basis of the tests that various people were all to be held to have participated in or committed the murders concerned, the fate of the people varied. Some were shot if they had actually carried out them, but some were hanged if they carried out the murder, and others were sentenced to imprisonment if they had been hanging around at the back of the car, which would take them out. And I just wondered, is that where proportionality would come in?
I would respectfully agree, my lord, that certainly in our sense of criminal justice, proportionality comes into sentencing rather than liability.
And would it come in here? Where I'm just asking because if one found that yes, technically, or maybe he was he could say he was participant, committed, but he wasn't the person who actually did it and so on, and he was a relatively minor role, enough to get him in. But would that be a sort of? I'm just asking. Is that sort of reason why one might say, well, okay. Yes. But it wouldn't be. It would be disproportionate in his case to apply the thing.
I would have to accept that, strictly speaking.
That what? I'm sorry.
I would have to accept.
We're twice as far apart as we used to be in the committee room one.
Yes, I'm sorry. Lord, I would have to accept that, strictly speaking, as a matter of law, if the executive correctly directs itself as to the legal elements of the crime said to have been committed, whatever it may be, then, strictly speaking, proportionality will not be relevant to that exercise. However, what I would respectfully submit is that one of the fundamental principles which we do ask the court to endorse in this context is that because one is dealing with an exclusion from a fundamental right, and because of the humanitarian protection purpose of the Refugee Convention, we do suggest that, as it were, the executive should not be approaching this exercise with a great desire to exclude people. It's very much the exception rather than the norm. If otherwise, he would qualify under the Refugee Convention, well-grounded fear of persecution, etc., then that question might well tip the balance if you're assessing the facts and whether the grounds of liability, whether there are serious grounds for considering, etc. So indirectly, it might come in that way.
It's odd because, of course, the way the thing is phrased, for example, in the directive is excluded.
Yes. Yes.
Which doesn't sound as though there's much room for discretion.
Lord, that's right. It's excluded, but that doesn't mean that one should have any kind of presumption or any inclination. My Lord's point perhaps earlier in relation to how one need not look much further. That kind of language in paragraph 105 of Gurung, with respect, does lead to this kind of danger, that the eye is taken off the right ball. You start to think, well, if he's a member of that kind of organisation, then probably I'm starting from the supposition that he's not just somebody who knows about things, he is a member of a joint criminal enterprise. So I am forming the view that he has committed a crime. And Lordship pointed out yesterday, Article 1FA uses the word he, so not the organisation. You are saying this person is excluded because he has committed a crime. The paragraph uses the word crime or crimes 4 times. Not he's a member of a very bad organisation, not that he may have done very bad things himself. You are reaching a conclusion. Put aside the standard of proof for a moment, but the conclusion is, I consider that you have committed a crime as defined in the international instruments.
But you can commit it, as I think everybody accepts, by conduct which would fall far short of criminal responsibility under domestic law. I mean, aiding and abetting, it goes beyond that, otherwise participating or otherwise assisting. And if you are...
No, with respect, otherwise participate comes in the directive.
Yeah, but I mean, are you saying that you're going to contend for a position less wide than the directive?
No, what I am going to contend for is that the directive is no wider than the convention.
And are you reading also the words of Article 25 and 30 of the ICC Charter in?
I am.
Statute, I should say.
I'm not only perfectly prepared to accept that, but I positively advance that as being the correct approach, which in substance is what Lord Justice Toulson said, and it is his judgment which is said to have been wrong in law by the Secretary of State in this appeal.
Certainly, if you're looking to see what could be prosecuted, you have to go to Article 25, don't you? I mean, if it doesn't fit within that, then it's outside the, the scope of the prosecution, and therefore you would have thought wouldn't be in for the purposes of Article 1FA.
Yes. And Lord, this is, I hope, the distinction I was seeking to draw earlier between the nature of the decision maker being different from the substantive elements of the crime said to have been committed. And likewise, a standard of proof, even if it is different, we may have to have a debate about that, but if it is different, certainly it's common ground between us that the standard of proof of the Secretary of State and the tribunal, if this were an appeal, is less than the criminal standard of proof. No one is suggesting in this appeal that it's the criminal standard of proof. But that does not detract from the need, as a matter of public law, for the executive to ask itself the right questions. If it is saying that you are excluded because I consider you've committed a crime, it does need to ask itself, what are the elements of that crime? And to answer my Lord Brown's question a moment ago, the point is essentially this, that one then gets guidance from the international instruments and where there is relevant case law from the case law in the tribunals. There's a large element of common ground between us about what those principles are, but not complete unanimity between us. But the essential point is that the Secretary of State didn't even begin to undertake that exercise. My only friend has. He's begun to undertake the exercise in the course of this appeal. But the reasons of the Secretary of State betray, in my respectful submission, a misdirection of law.
But I mean, supposing that the Secretary of State had expressed her conclusion as being that he had knowingly participated in the crimes in question.
Yes.
That would be all right.
Well, my Lord, it would still depend on what knowingly participated was based upon. But yes, that would certainly begin to address the problem.
I mean, it's not the elements of the crime. The elements of the crime are murder or whatever it is. But it's the reasons. It's how it comes to be held, to be involved in the commission.
Exactly. Well, the Lord is right. The way we've expressed it, and I hope it's the same concept in law, but our language has been modes of liability, which is essentially the different modes set out in Article 25 of the ICC statute, coupled with the mens rea requirements in Article 30. And I don't want to go into it now because I'm coming back to it, but it does include intention as well as knowledge.
Yes.
But I mean, all these things like membership and your position in the organisation, are they not? I mean, are they not pointers which may be used in order to infer that you have the sort of knowledge and that you are involved in and support and so on?
Yes.
They're not themselves the answer, but they are factors which lead you to conclude, which may justify the inference, that the person was somebody who participated according to the criteria in Article, whatever it is of the...
Lord, that's right. And one of the difficulties on analysis with the approach in Gurung may be this, that unlike what the Court of Appeal attempted to do in this case, which is to set out the right legal questions, and then say, as all the cases really say, then it's a question of fact for you to decide. Much of the guidance appears to elevate guidance on what are essentially questions of fact into what might be taken, and there is a real danger of this, might be taken to be effectively presumptions, certainly coming close to presumptions of law. And one sees the danger exemplified when you see how it's formulated in paragraph 34 of this decision letter, when Gurung, which has quite a long analysis, is then encapsulated in this sentence, and in my respectful submission, does not begin to address what are the legal elements of the crimes said to have been committed.
Where does the word acquiescence come from? I mean, I don't think that's in Article 35.
It's not, my Lord.
It's in the UNHCR.
It's UNHCR. And
Paragraph 18.
And exactly, my Lord is right. It's paragraph 18. It was quoted in Gurung, and so this decision letter has taken it from there, no doubt. It's actually shorn of many of the caveats and the need for caution, which the UNHCR also expresses, and I'll come back to that if there's time.
I mean, I do have a recollection, I mean, certainly in English law, I mean, you can go along with something,
yes,
but you may be said to acquiesce in it. You yourself oppose it. I mean, there was a case from Hong Kong or somewhere like that where the person was held guilty because they went along with the thing. They just acquiesced. They would rather it hadn't happened, but they went along with it.
Lord Justice Toulson, I apprehend, was aware of that, precisely that kind of difficult case, and he said that there were dangers again with words like acquiescence amounting to complicity, because it again takes the eye off the correct ball. Now, it may be that on the very specific facts of a particular case, if you had the pub example, or there's the massacre of civilians taking place in front of your eyes, if that was what was being alleged, then one never says never. One never wants to say, because it's such a fact-sensitive area. But the point is that they don't say there was this massacre of civilians and you were a knowing participant in that. They put it at a much more abstract level, which is effectively to say that the organisation is a criminal organisation. That's a large part of my learned friend's case against me. That's why he's drawn the analogy with the Gestapo, as I understand it.
I suppose what they could have said, although they didn't, is that in this regard, paragraph 18 of the UNHCR document tells us that,
Yes.
and then they quote almost verbatim the sentence.
They could, my Lord. With respect,
if they'd done that, what would your position
my
be?
argument would have been essentially what Lord Justice Toulson said, that the UNHCR guidance with respect itself is not a complete and accurate account of the relevant criminal legal principles. And there are real dangers in introducing concepts like presumptions, acquiescence amounting to complicity, because of the voluntary membership of the organisation. That's what it's coming from. It's not knowing about a crime, it's knowing about the activities of an organisation. There's the subtle shift which is taking place in the reasoning. And it underlay a lot of my learned friend's submissions, when he often elided with respect knowledge in relation to crime and knowledge in relation to purpose. Knowledge in relation to common design might be one thing. Knowledge in relation to general purposes and activities of an organisation might well be something else. You do have to analyse the specific facts of an individual case. And with respect to my Lord Brown, that's the kind of exercise that hasn't yet been done in this case. And I will respectfully invite this court not to anticipate one way or the other what the outcome might be if the decision maker asked itself the right legal questions, then went about in a fair and reasonable way answering those questions. The ultimate outcome might be the same as before. That's inevitably the nature of our law of judicial review. But it might not be. And normally, my Lord, if I may say so with respect, normally the court takes the view that if it might not be, that's what leads to a quashing, which is what Lord Justice Toulson did in this case. Lord, I've spent long enough, unless I have more questions from your lordships on the decision letter. May I move on to a different topic
Yes,
now?
I think you will.
Grateful. My lords, what I wanted to go to next is just to follow the scheme of our printed case, without obviously repeating it. I adopt all of it and highlight some material which is relevant to passages in our printed case. My lords, the analysis of the first part of our submissions begins at paragraph 11 and proceeds through to paragraph 26. And much of this, I now apprehend, is common ground in the light of the way my learned friend has put it at this hearing. But can I just emphasise certain features of our argument here? The first is that at paragraph 12, that, forgive me, that's a misprint there, that of course ought to be 1FA.
Sorry, which paragraph are we looking at?
Paragraph 12 of our printed case.
Yeah.
There are some glitches that arose. I'm sorry about that.
I'm not quite
It
sure.
wasn't the
what
version
is
that I signed off on, but I apologise that at some stage the computer, I think, has changed some of the wording and lettering.
Yes.
But I hope it was tolerably clear.
Well, I thought it was readable.
Yes, I'm great.
Glitch.
So we emphasise there that the word crimes is immediately introduced, and it as defined in the international instruments drawn up to make provision in respect of such crimes. The second point we make just above paragraph 13 is that the provision, because it's an exclusion clause, should be interpreted restrictively in order to facilitate the protective purpose of the Convention as a whole. I'll pass over the following paragraphs, if I may, and go to paragraph 18 and observe that the drafting history of the Refugee Convention shows that it was specifically crafted in an open textured way in order to take account of subsequent international instruments. We've given some references.
It's all common ground.
I think
It is now, my lord. Can I give an additional reference to the passages we've set out at paragraph 21? Because it may matter for this reason, that the London Charter, our submission is going to be, was unique in the way it was drafted. May I come back to that? But just generally, under paragraph 21, as well as the references we've already given, your lordships may find it helpful to look at Hathaway, which is volume 14, tab 105, at page 217, and also a fairly recent decision of the Federal Court of Australia. I'll just give the reference for now in view of time. It's a case called SRYYY.
SRYYY.
Yes. It's volume 13, tab 96.
96, thank you.
Paragraphs 27 to 29, and also 31 to 32. 27 to 29 and 31 to 32. It's a helpful commentary, if I may say so, from a court in Australia about the development of the law in this area and the very specific reason why you have that reference to international instruments generally and not just the London Charter. The original draft was only going to refer to the London Charter. My lords, can I then turn to the second part of our submissions, which in the printed case begin at paragraph 27 and continue to paragraph 34. I want to come back in a moment to look at the terms of the London Charter, but can I introduce the topic by looking at, in more detail, the text from Professor Casese, which is referred to in paragraph 30 And the reference, my lords, if I can please go to it, is volume 14, tab 101.
What's the date of this?
I'm sorry, my lord?
What's the date of this?
The date is 2003. I think my lord observed yesterday that it falls about halfway between Judge Casasi's judgment in Tadic and the recent amicus brief in 2008 that he was also a contributor to.
I mean, we know that, although this document doesn't actually tell us.
Yes, the reference is in our footnote
Thank
in
you.
paragraph 30 of our case.
I see.
My lords, I invite attention and commend the whole of this section, 7.2, to the court, but in view of time, can I highlight some passages? At page 137, after the two principles that we have set out in our printed case, Professor Casasi says in the first full paragraph on 137, it follows from the first notion that, among other things, no one may be held answerable for acts or omissions of organisations to which he belongs unless he bears personal responsibility for a particular act, conduct or omission. An exception was, however, provided for in Articles 9 and 10 of the Statute of the IMT at Nuremberg. And I hope it will suffice for present purposes if I simply invite attention to the text of those provisions there rather than go to the underlying convention. Now, as my Lord Walker observed yesterday, this was a very special kind of text because, as Professor Casasi says just after the indent under Article 10, thus mere membership in a criminal organisation was regarded as criminal. This was a unique provision in international criminal law, as far as I understand it, in that it gave an express power to the tribunal to designate certain organisations as being criminal organisations. And that scheme, as Professor Casasi says at the bottom of the same page, was then confirmed by Control Council Law number 10 of December 1945. What then followed, as Professor Casasi helpfully summarises here at pages 138 and 139, was that there were a number of decisions of the International Military Tribunal, which in fact attempted to mitigate in practice the full rigour in law of that criminal prohibition. And I don't take time over it now, but I invite attention to the summary of Goering and others at the beginning of page 138, and also the references to Krupp on the following page, which was an IMT, forgive me, a US tribunal sitting at Nuremberg, and also another US tribunal in a case called Krauch and others, known as the IG Farben. That's the well-known German company, the IG Farben trial. And in a sense, the attempt in practice to mitigate the rigour of the law is summarised in the final sentence. The tribunal took pains to emphasise that they did not bear collective responsibility, but could only be found guilty of individual criminal liability.
It's quite interesting that in that paragraph of the United Nations document, it's suggesting it'd be rather nice to have lists of organisations.
Yes.
It's going back to this sort of
Yes,
idea.
my Lord, I'm grateful to my Lord for raising that, because it enables me to make a submission that I would have wanted to in any event, and it's this, that one has to be careful in this area to draw a distinction between the concept of lists of proscribed organisations, including those which have been proscribed as being terrorist organisations, and the concept of criminal responsibility for criminal offences. And at the risk of oversimplification, of course, one fundamental distinction is that criminal law focuses on individual personal culpability. However that might be defined, however broad it might be, and one accepts that it's broader than aiding and abetting, other things come in, I accept that. But at least it focuses on the right question, which is, what has this person done to make him personally culpable of a crime, not what is the nature of this organisation. And you could well have, and your lordships know from other cases I know pending in this court, a list of proscribed organisations. That is not a list of criminal organisations. I hope I have made that point clear, my lord. My lord, I've said that the formulation of the IMT Charter in 1945 was unique, as I understand it. Certainly I'm not aware of any subsequent attempt to legislate in that way, even to give a power to a tribunal, a court of law, as it were, to designate an organisation as criminal as such. It's certainly not a feature of modern instruments like the ICTY statute, the Rwanda statute, and now, most relevantly perhaps, the ICC statute, which is, of course, of general application around the world. It's been ratified by a very large number of states. It's of recent application and has entered into force recently, and is not limited by subject matter, as the other tribunals have been. So Yugoslavia, former Yugoslavia, obviously Nuremberg was Germany, Tokyo was Japan, and so on and so forth. My lords, at paragraph, forgive me, in our printed case, the part 3 of our submissions begins at paragraph 35 and proceeds to paragraph 61. And again, much of this will be common ground, I know, certainly in the light of the way my learned friend has put it in the hearing, but we place emphasis on the dynamic nature of the evolution of the law in this area, as reflected, for example, in the UNHCR's Lisbon Expert Roundtable of 2001, which is quoted at paragraph 36. We note that the border agency itself, at the end of paragraph 35 of our case, gives advice to immigration officials that for practical purposes use should be made of the definition set out in the ICC statute.
I mean, it's again A at the top of that page, isn't it?
It is, forgive me, my lord, yes. Yeah. I hope elsewhere we got it right, but sometimes I apologise we got it wrong. And then we invite attention, I hope it's sufficient, my lord, if I just use the printed case for present purposes. I can go to the underlying ICC statute if you'd like me to, but at paragraph 39, we've set out Article 30 of the ICC statute, and over the page we have set out, in paragraph 40 of our case, Article 25.3 of the same statute. And I've referred in submission to these as essentially, in Article 30's case, governing the mens rea, and in Article 25.3, governing what we perhaps inelegantly have called modes of liability. So I agree with what my Lord Rogers said to me earlier, that it's not strictly speaking the elements of the offence, but it is a way of becoming an offender, a mode of liability.
And D, because, I mean, C and D,
Yes.
because, I mean,
Yes.
C is aids, abets, or otherwise assists in the commission.
Yes?
But D takes it even wider.
Yes.
In any other way contribute.
Yes, my lord, that's right. The gloss has, of course, been put on that in the sense that the jurisprudence of certainly the ICTY, and I would commend this, and I don't think it was disputed, would suggest that an adjective has to be inserted there, which is make a significant contribution. So that's one point. But also, this is fundamental, that all of that provision is dealing with ways of committing the crime. So when it talks about attempted commission of such a crime, a common purpose is not the common purpose of an organisation. It's a common purpose of a group of people who have decided in some way to commit a crime. So the common purpose is much like domestic criminal law, which talks about common design. And of course, one is familiar when juries have to be directed about how a plan or design doesn't have to be in writing or even expressed in words. It can be a nod or a wink. Of course, one is familiar with those sorts of ideas, but at least the fundamental concept is still focusing on the right question, which is the common design to commit a crime, not...
Sorry, I'm not sure how this works. I mean, take our, broadly our case, and just assume somebody joins or indeed becomes head of the intelligence division of LTTE, and they know perfectly well that once a week there's an atrocity. Somebody attacks civilian targets.
Yes.
I mean, that's part of the scheme. They think that's going to produce results in the long term. But they, frankly, they don't know. They haven't the least interest in which week, which particular place, which target. I mean, they just know they're participating and making a valuable, significant contribution to the operations of a body which does that.
Yes.
Now, are you suggesting that that isn't within the compass of 25?
My Lord, may I try to answer that by reference to going to the ICC statute, because it's important in that context, I submit, to have in mind Article 28, which we don't currently have in this. So it may be helpful if we can go, please, to Volume 4 at tab 33. And there are dangers with respect to going down that.
Superior responsibility.
Yes, exactly, and there are dangers with that, my Lord, for this reason.
Well, I'm sorry, I mean, I'm not going to deflect you, but just take my illustration. He's not the head of it, but just assume that he's the chap who produces the guns. He makes sure that the weaponry works, or was a bomb maker or something.
Yeah. Well, first of all, one would have to define accurately the elements of the actus reus, and it's not with respect. It's not in this area. It's not like domestic law, where it's just heinous acts like murder or torture or whatever it may be. In the case of crimes against humanity, for example, there are what are called in international parlance the chapeau requirements. The main one is that there has to be widespread and systematic use of these crimes against a civilian population. War crimes takes its flavour from another set of chapeau requirements. So, first of all, you would have to have all of the chapeau requirements.
Well, I've put those into the equation.
Exactly. I understand that, my Lord. Secondly, the answer in principle is, it would depend on the facts. It might well be. If you direct yourself correctly, according to the ICC statute, as to the modes of liability and the mens rea, which includes not merely knowledge but intention, then the answer might, if you do the exercise correctly, depending on the evidence, and you've acted fairly and reasonably, the answer might be yes. But, my Lord, what I do want to suggest, however, is that there are dangers. There are dangers with having too broad an interpretation of Article 25, for this reason, that Article 28 is expressly designed to cater for situations of those who are in a position of command. And there are two dangers. One is this, that if one has too broad an interpretation of Article 25, which is personal responsibility, as opposed to what I will call loosely vicarious responsibility.
So Article 28 is vicarious.
Exactly, yeah. It's not the language they use, but I use it because we tend to use it in our own law of tort, so it can perhaps be understood. But the point is this, that if you have a very broad interpretation of Article 25, then it's difficult to see why you would need Article 28, because somebody would be personally responsible because they were in a position of command, they could have done something about it, and they knew that this is the sort of thing that goes on. That's one danger. The second danger is that if Article 28 does have a function, and presumably it does, it obviously carries in its own terms certain limitations of legal principle. There are important criteria which have to be satisfied in Article 28.
Sorry, just where are we finding 28?
Lord, it's volume 4, tab 33.
Thank you.
Page 19 has Article 28.
Yeah,
And your lordship see that, without reading them all out, that in essence, it's not just enough to say, well, somebody was a commander. There are elements of knowledge, for example, in A1. There's an element of failure to take all necessary and reasonable measures within his or her power. Now, if Article 25 could hold a superior, a person in a command position responsible as a personal participant to a joint criminal enterprise, in our respectful submission, that carries with it the danger that somebody might well not be caught by the criminal liability specifically intended to cater for commanders and other superiors in Article 28, and yet just on, because of the abstract nature of the organisation and just the way that it tends to work, that person would still be criminally liable. And one always focuses again on that fundamental principle of criminal law, of personal culpability. And in my respectful submission, one should be slow to arrive at that interpretation of this treaty. Of course, it should be read as a whole.
So I'm not sure I quite follow. Taking Lord Brown's example, you referred to intent. What did you mean by that?
Well, I meant that's the language of Article 25. Forgive me, of
Yes,
Article 30.
I know. Yes, 30, and it talks about the relevant element of
Yeah,
something.
and then it defines intention.
Yeah.
And I don't in any way seek to detract from the definition of intention in that paragraph. But what I say is that if a decision maker is going to say that somebody has committed a crime, then they have to direct themselves to those mental elements.
I mean, here we have a bomb maker, as I understand, to take the example, the kind of thing Lord Brown had in mind, who knows that his bombs are used, not just, or his weapons or whatever it is, are used not just against the conventional forces and so on, but he knows it week in, week out. He doesn't know when it's going to happen, but it's going to be an atrocity using the things which he is providing. Now, he knows what he's doing, he's making these things and so on and so forth, and he knows what is being done with them. Now, is that not enough?
Well, Lord, it might be depending on the evidence, but the legal test would be the one in Article 30. First, it requires the material elements are committed with intent and knowledge, and then in relation to intent, to particularly B, and of course I accept that in principle there is the second of those legal possibilities. Of course I do.
It's awareness for what will occur in the ordinary course of events.
Exactly, and then it will become a question of fact whether that was made out in the particular circumstances. But with respect, my Lord, one can't just give an abstract answer and say, well, because this is the kind of organisation that does these things, and you're in a position of command, it necessarily, that starts to raise things to some kind of presumption of law, which is the language of Gurung and language of the decision letter in this case. There has to be an intent to perpetrate the unlawful act, not merely knowledge of it. And so that would not necessarily be an unlawful complicity case, if I've understood my Lord's question to me correctly. But I say you have to apply the correct legal approach in 2B in particular, then look at the facts.
I mean, to come to the facts of this case, if you're somebody who's engaged in transporting materials to enable people to travel from the east side of Sri Lanka to Colombo and be equipped with civilian clothes, would it not, on the facts we have here...
Well, not necessarily. Well, there are great difficulties with applying it to the facts of this case, some of which I've already outlined, that hasn't been gone into by anyone fairly or reasonably so far. But the chapeau requirements, my Lord rightly said to me, assume in my hypothetical scenario the chapeau requirements are met. We don't necessarily accept that the chapeau requirements are met in this case.
I'm sorry. You don't accept that there is evidence before the Secretary of State that there has been routine...
widespread and systematic atrocities against civilians at the material time, because some of the incidents, I was going to come back to this, if I may, when I deal with the facts. But the assassination of Rajiv Gandhi has been mentioned more than once at this hearing. That was in 1991, when my client was about 8 or 9, and before he'd even joined the LTT as a 10-year-old. So one has to be very, very careful. If one is to say the chapeau requirements have been met at the time of the relevant conduct, this is the virtue of the correct legal approach, which is what Lord Justice Toulson commends, is to focus on these provisions in particular in the ICC statute. Focus in relation to, note the word conduct.
Well, it's both conduct and consequence.
Oh yes, I've already said more than once, I do not detract in any way from the full text of these provisions. But what I do say is, these are the provisions that have to be applied. These are the principles that have to be applied. One can't just make some kind of generalised assertion as to the nature of the LTT or a particular division of it, and then say, well, there you are, you're a voluntary member of it, you were second in command. There's a very live factual issue in this case, my lord.
When the Secretary of State is considering what the organisation is like at the time when the person concerned has joined and is over 18,
Yes.
does the Secretary of State have to exclude from her mind all that she knows about the organisation as it was and what it did before he was 18?
Lord, yes, because yes,
Or
yes,
she can't.
yes,
Can I just
forgive me, yes.
Can she not say to herself, yes, well, of course, I can only really look at what it's doing while he's over 18, but
Yes.
in considering what kind of how to interpret what it does,
Yes.
I can take into account the fact that hitherto it was assassinating Mrs.
Yes.
Gandhi and doing all these other things.
Well, yes, that's right. I would accept that.
You accept that.
I will accept that. But I would still say that you then have to focus on the particular conduct in question. Particular conduct in question.
His conduct.
Well.
When you say the particular conduct, whose particular conduct?
Well, it's for example, it might be if it's a murder of civilians, it would be that conduct, and then its consequence, which might come in through Article 32B in particular.
I mean, it's a provision of equipment, let's say the
Yes.
bomb or whatever else it
well,
is, in the context
Yes.
of a group that,
Lord-
when it's equipped with this sort of thing, does,
Yes. Well, look-
in the ordinary course of events.
The answer would depend on at least these two things. One is that you would have the individual said to be excluded under 1FA would have to have intended and known that persons were being transported and that they were going to commit a war crime or a crime against humanity. And secondly, my lord raised the question of wearing civilian clothes. Well, there are many reasons why a member of the LTT at the material time might wear civilian clothes, not necessarily perfidious ones. They could be, because they're going to engage in a terrorist atrocity, or they might not be, because it was a prescribed organisation for much of the time. You might well, understandably, not wish to have your identity known, because you were going to have consequences taken against you, even if you were yourself only engaged in what has been called ordinary war fighting.
But I mean, you know, the fact, I should have thought, actually can be stated this shortly. When he was 18, he became the leader of the mobile unit, which did what paragraph 3 and 5 of the State Facts Issues tell us. They transporting military equipment and
Yes.
members
Yes.
in civilian through the jungle so that they can go in civilian clothes to Colombo.
And he took,
Now he's doing that from his 18th birthday
Yes.
for 5.5 years, with an interruption after 2 years for just 2.5 months to become one of the chief security guards for for the head of the intelligence division.
Yes.
Otherwise, he is the leader of the mobile unit for 5.5 years till April 2006, when he becomes the 2IC of the entire combat unit of the intelligence division. I mean, that's, in a nutshell, that's what it is.
Yes, well, that's as far as the evidence goes, as agreed in the SFI. The respondent would wish to emphasise, of course, the beginning of paragraph 2, that what he was a member of was the combat unit of the intelligence
Well, I've taken it up from when
Yes,
the fourth line of
Yes.
paragraph 3,
Yes.
which is around the time of his 18th birthday, September 2000, he then starts leading this mobile unit, and that's what he continues to do right up until April of 2006, when he becomes 2IC, with the sole exception
right.
of the end of April 2002 till the beginning of July 2002,
Yes.
when he operates as this chap's
But
one
it's
of
his
chief
case, and
security.
I don't invite the court to decide whether this is true or not, but it's his case that
But you don't dispute he's got reasonable or strong, whatever it is, serious reasons for considering that that's his involvement.
No, that's right. Those are the facts,
Yeah.
so far as they're currently known to the
Yes.
court and the decision maker. But we would wish to emphasise that that's all a reference to the combat unit of the intelligence division, his role as a guard. He was effectively there to fight if for example, an intelligence officer or this man, Poter man, were to be attacked, then his role is to fight in traditional combatant fashion those people. Now, Vavonia is mentioned in the middle of paragraph 3. That's in the north of the island. That's as far as he accepts that he took them. There's no acceptance that he had any knowledge or intention as to what they were then going to do. Now, that might have to be explored, and it might be, if it's properly put to him and fairly reached, that in fact he must have known, and that therefore he falls under Article 32b.
I mean, in that sentence, and also in paragraph 5, it's the supply of military equipment
Yes.
to people wearing civilian clothes.
Exactly,
And surely that indicates what, in the ordinary course of events, they were likely to do with the military equipment. Why else should they be acquiring military equipment?
Well, look, I can't say what the answer that the client would give to that, but these things have never been put to him. This is the extent of what he has accepted. It's perfectly possible that he might wish to say that there was a legitimate military attack. As far as he was aware, that's all it was going to be used for. In his supplementary statement, which is in page 108 of the appendix, the point is made at paragraph 9 that although he was leading one subunit, he, including to settlements closer to Vavonia, that's where the SFI has come from.
Yes.
I did not know what these members do.
Sorry, paragraph, which, I got the page.
Paragraph 9,
9, thank
middle
you.
of the page, where your lordship sees Vavonia. And it continues to say, I did not know what these members do. We are not told what the intelligence members are going to do because the information is restricted. This is a comment that's made by the Secretary of State, that it's a secretive organisation. Generally speaking, obtaining intelligence from government-controlled areas, then they will go in civil dress and pose as civilians. Now, I hope in fairness, my lords, I've accepted throughout my submissions today that if a decision maker correctly directed herself in law and fairly and reasonably approached the evidence after giving a person the chance to comment on the case against them, it might well be that one conclusion to which one could come is that the elements of complicity in a crime are made out. But what I do respectfully submit to this court is to endorse the approach of Lord Justice Toulson, which is to say, well, they never approached it in that way. They asked themselves the wrong questions in law, and therefore they've got to do the task again, correctly in law and fairly and reasonably. That's a conventional judicial review approach. That's what this case is. My lords, I'd finish subject to any questions from the court, dealing with my summary of part 3 of our printed case. But say that I do wish to go to the international case law to some extent. Much of it has already been very helpfully gone through by Mr. Iker yesterday. And so there's a great deal of common ground, as has now emerged. My lord, can I just say that first, the case of Tadic is dealt with in our printed case at paragraphs 43 to 45. And I will just go back to that to make a few comments on the judgment in that case. It's to be found in volume 9 at tab 69. Now start the citations I would wish to emphasise at page 80 of this judgment, page 80. At
80.
80, yes. And the heading,
Excuse me.
and my lords, the heading, the individual criminal responsibility of the appellant for the killings. This, of course, is an ICTY case. So when it refers to the statute, it's referring to that tribunal's statute.
Sorry, did we get the sort of basic context, factual context of this case? I'm not sure if I
Well,
have any recollection of that at all.
it's-
What basically was this chap doing?
it's difficult to summarise. He was obviously one of the main leaders in Tadic is a well-known name and defendant in this tribunal. But Lord, it's certainly widespread in this case. Yes. The Court of Appeal, perhaps most helpfully, has a summary of the underlying facts at paragraph 34 of the judgment of Lord Justice Toulson.
34.
Yeah, it may be that that's a helpful synopsis. I hope it is.
Ah, yes.
Your Lordship recalls that.
Yeah. Oh.
He's the well-known Bosnian Serb. Now, look, what I want to get out of this, of course, and much of it is common ground, is the general legal principles. And emphasise again that none of this is to be found in the decision letter or in Gurung. Gurung referred to Tadic, but this is the criticism that Lord Justice Toulson made of it, we submit rightly, that it's almost a sort of passing reference to Tadic, and they go into all the things about presumptions and so on, which are unhelpful. Now, the first basic principle is summarised at paragraph 186. The basic assumption must be that in international law, as much as in national systems, the foundation of criminal responsibility is the principle of personal culpability. Nobody may be held criminally responsible for acts or transactions in which he is not personally engaged or in some other way participated. And then the judgment turns to the possibility of joint criminal enterprise. As Lord Justice Toulson observed in our case, there was a suggestion that the whole concept of joint criminal enterprise was simply not applicable in international criminal law. Professor Dershowitz advanced that proposition at one time, and there's reference made to that in the Court of Appeal. But it's common ground between us that the idea of joint criminal responsibility as an aspect of personal culpability does exist in international criminal law. And your lordships have already heard about the three distinct categories of collective criminality. That analysis begins at page 83, paragraph 194 and following. The first is from paragraph 196. The second is at paragraph 202, but that's admittedly not relevant because that's the so-called concentration camp cases. I want to respond to a point my learned friend made yesterday about footnote 245 on page 86, where he referred to the case about Radetzky and so on, and emphasise what my Lord Brown observed yesterday, that that's a very different kind of case. There you were focusing on the nature of the organisation because they were members of Einsatz units whose express mission, well known to all the members, was to carry out a large-scale programme of murder. And that's the context in which the cook in the galley of a pirate ship, note there's not any ship, it's a pirate ship, which is there being referred to, arose. And then the third category is outlined from paragraph 204 onwards, and I would respectfully endorse what my Lord Rogers said yesterday, that this really isn't a third category case, at least as the facts currently stand, because it's a riposte or a rebuttal point.
I mean, category one, and just looking at it last night, it seemed to me categories 1 and 3 put together are very similar to English
Exactly.
English law.
Well,
3
yeah.
is the sort of Powell and English
Exactly.
extension.
Absolutely.
And one is a sort of ordinary joint enterprise. Or
Well,
joint-
I would respectfully agree, and I would respectfully suggest that there's really not a great deal of mystery about it. Because suppose you had, I know it's difficult in the domestic context to find a direct analogy, because gangland criminals they tend not to be in the sort of organisation that you might find at the international level. But doing one's best, I mean, just to be a member of a gang, maybe even in a high position of responsibility, doesn't mean that if you applied well-known, familiar principles of criminal enterprise liability that we know about the pub fight on a Saturday night, it wouldn't follow that because you knew that in the ordinary course of events, people who are subordinate to you in your organisation, perhaps another, especially if they're in another branch, you would have to focus on particular conduct which is said to be criminal, and then ask who has committed the actus reus, who has committed that with the relevant mens rea. In principle, the answer you might come up with is yes, this person did form a party to the crime. But you can't just have some kind of broad brush abstract answer to those questions because of membership of the Cray gang or something of that sort.
No, but I follow that entirely in the domestic context, but surely, I mean, it is different in the international context.
Lord, with respect, no, it's not. And that's the point. It's not different, save possibly for that very early example we saw when the law in this area was only at its inception, when the Allies took the decision to draft the IMT statute in a very particular way, in a unique way, and gave the tribunal the power to designate, for example, the SD, the SS, and the Gestapo to be criminal organizations.
But, I mean, for our law, you need to be, at the very least, an aider and abetter.
I see what
But
you mean.
under international law, it goes further than that, and therefore you don't have to relate it so specifically to individual crimes.
Clearly, my Lord, there's been an incremental development.
Exactly.
And I don't want to suggest that it's identical to domestic law. But what I do want to suggest is that it's rooted in the same moral principles, particularly the notion of personal culpability, because it's crime that one is talking about. And therefore, the best way to find guidance on what the applicable principles are is to look at the relevant international instruments. Article 1FA actually tells you to do that. And in my respectful submission, I keep coming back to our fundamental submission, is here there was a misdirection of law. The Secretary of State did not direct herself in accordance with those principles. And it's not with respect for any court on a judicial review challenge, normally, to anticipate what the outcome would be if it were correctly applied.
Judging by the footnotes, much of the discussion you're directing our attention to in Tadžić, much of the discussion is based on the Nuremberg cases.
Yes, Lord, that's right, but that's because, as I said earlier, the statute having contemplated criminal organisations, then there was the attempt to mitigate that in practice, which did focus on personal culpability, even in those cases. But of course, it's not one to the exclusion of the other. I mean, there are lots of incidents of atrocities. It wasn't the membership of the organisation. So, for example, my Lord pointed out earlier, the sentence you got might well be different. If someone was simply a clerk in the SS, that might well be very different from actually having been the person who pulled the trigger in the back of someone's head, or the commander who says, well, you guys go out into the forest of Katyn, whatever it may be, and kill people. So, my Lord, one mode of liability, the references in the Nuremberg cases to personal responsibility and so on, which are referred to here, are not illogically there. They would be there for a good reason, which is that you might well have had the SS commander or the shooter or whatever who was charged.
As I understand it, the criticism which has been mounted against the Tadžić judgment, to which, of course, Professor Cassese was a party, relates to three, the third category,
Yes.
and is said, and there it is said
Yes.
by some commentators, German commentators and so on, that it goes too far.
Exactly, because, again, one is reluctant to draw analogies too much with domestic law, but one remembers the difficulties with the concept of felony murder and things of that sort. That so if you go beyond the common enterprise, but in a way that was foreseeable, and one sees difficulties, and some people have a moral repugnance to that, others might not.
And there are, I mean, it's exactly the same kind of discourse that has arisen in English law as to whether or not you should, because the mens rea is said is different when you extend it, and exactly the same objection is made by some of these commentators to the Tadic judgment. But it's because the third thing goes further than that's the criticism of Tadic.
Exactly, that's right. But for present purposes, it's common ground that is where international law stands at the moment. Article 25(3) of the ICC statute formulates it in a treaty, but it largely reflects, we submit, the case law of the ICTY.
But as you say, it's got nothing to do with our case, because nobody's suggesting that,
No, exactly.
that these atrocities went beyond anything that was...
Precisely so, my lord. So when it comes back to the first mode of liability, the question, really, the fundamental contrast between us is, well, is it enough to say that you're a voluntary member in some position of command, in some, it's not entirely clear, and the facts at present, branch of an organisation that on any view is not an organisation which has only one purpose, which is to kill civilians in large numbers, but on any view is an organisation which had more than one purpose and more than one activity, and was, to some extent at least, a traditional fighting organisation with uniforms, to some extent at least was a traditional independence movement. In that context, to start relying on presumptions based on voluntary membership and some kind of position of command in some aspect of the organisation, in my respectful submission, that's where the dangers lie. That you're going to make assumption. It talks about presumption. You were complicit in a particular crime because of that status and that nature of the organisation.
Is there anything more to be got out of Tadic?
I wasn't being...
I mean, 186, I can see the value of that paragraph. But what then follows is a narrative of a whole series of cases of various kinds, including mob violence and operational concentration camps.
No, I wanted largely not to repeat what my learned friend had gone through, but to respond to some of the observations he made on the cases. Otherwise, we've made our submissions in the printed case to a large extent, and I'm not repeating those, obviously.
Thank you.
My Lords, the next case that I don't need to go to, but we've referred to in our printed case at paragraph 46, is the Brunin case, which was referred to below. I don't think my learned friend went to it, so I don't need to go to it either. But our analysis of it is in the case at paragraph 46. Kreisnick, we've dealt with at paragraphs 47 to 49 of our case. And it's to be found, it's a very long judgment, and I only need to make a few short observations about it. It's to be found in volume 6 at tab 56. And my learned friend particularly went to some passages which I would like to respond to. The first is at paragraph 682, which is on page 236. Page 236, paragraph 682. And I just wanted to emphasise that on its facts, it's a very different kind of case, because Kreisnick's overall contribution was that he helped establish and perpetuate the SDS party and state structures that were instrumental to the commission of the crimes. And at the bottom of that page, the point is made by the appeals chamber that the impugned finding does not pertain to his alleged participation in the establishment or founding of the party as such, but instead to his help in establishing those SDS structures that were instrumental in the commission of the crimes, their emphasis. Then my learned friend referred particularly to paragraph 694 to 697. And I don't repeat what's said there, but in our respectful submission, on closer analysis, those passages, if anything, help us because they make it clear two things. First, that you have to make a significant contribution to the crimes, not to the activities of an organisation. That's the last 2 or 3 lines of paragraph 695. And secondly, they make it clear, as Article 25 and 30 do as well of the later statute, that you have to be a party to the criminal purpose, not just party to the purpose of an organisation. So those were the 3 authorities that, from the ICTY tribunal, that the Court of Appeal referred to. My learned friend has really not now sought to suggest that they were wrong to do so. And
I'm sorry, could you just say that again?
Yes.
Which bit are we looking at that isn't suggested to be wrong?
in the hearing in this court, the learned friend has effectively cited the cases that we and the Court of Appeal cited, which are the principal ones from the ICTY. Now, what he derived from them, there is some dispute about. May I turn to that topic now? My learned friend, at I think my Lord's invitation this morning, sought to formulate what the test is, and he, I think, had 3 propositions, which we would accept so far as they go, but they omit important elements as well. May I try to, as I understood him, remind the court of what he said? The first was that the person is part of a group of persons, such as an organisation. Secondly, that there is a common plan, design or purpose which involves the commission of a crime, which need not be previously arranged or formulated and may arise spontaneously. Well, that's the kind of thing we're very familiar with from the pub fight on a Saturday night. We accept that so far as it goes, but our comment on it, my Lord, is this, that that's still focusing on common design or purpose to commit a crime, not just a generalised participation in the common purpose of an organisation.
Well, he says a common plan, design or purpose which involves the commission of a crime.
Yes, he does. Yeah.
Well, I mean, why isn't that true of this case?
Because, well, at the moment, my Lord, I'm not applying these principles
see.
with respect. I'm trying to formulate what the principles are. But there's a danger with language such as which involves the commission of, because in our respectful submission, the cases we've just been looking at, and your lordships will go back to them, no doubt, talk about common design in this, or purpose, in the sense of the design is to commit a crime. That's the pub fight situation. It doesn't have to be an elaborate or express agreement, but it does have to be a common design to commit a crime. Thirdly, he submitted that the person participates in the common plan, although the participation does not need to involve the crime, may be assistance in or contribution, as long as the contribution is significant, and we accept that. That's a reflection of the ICTY case law. But the fourth would have to be that the chapeau requirements for either of the relevant types of crime exist, and they differ according to whether it's war crimes in Article 8 of the ICC statute or crimes against humanity.
So what's the source of this requirement of the chapeau?
It's now one sees it formulated in the terms of the ICC statute. So if you go to
Article what?
Article 7 and 8, those are the principal sources today. And fifthly, and most importantly, we submit that what his formulation omitted, as we understood it, was the relevant mental elements, which are helpfully today to be found in Article 30 of the ICC statute. And I will abbreviate them as being intention and knowledge, although I know my lords will have in mind the full text of those provisions.
I was attracted, as you know, by paragraph 21 of that German
Yes.
case. I think what you've been saying is all to be found there, actually, isn't it?
My lord, can we go back? Can we go to that, if I may? I was going to go to German cases.
Out of order, but
I'm entirely in your lordship's hand. Would it help if I go to the German cases in one go later? Because I do
yes.
have a note to deal with.
It
I
probably
hope your
would,
lordship will forgive me if I...
Yes, so don't let me take it out.
No,
But,
I certainly intend to go to paragraph 21 and the other German cases. So that illustrates perhaps the degree of common ground, but also an important difference between us. But the fundamental submission I keep coming back to, I'm sorry, is that there's no self-direction about any of that in the decision letter under challenge.
So I'm saying, just to go back to the chapeau requirements you called.
Yes.
Those are really, in the case of the court, those would be jurisdictional requirements. Is that right?
Well,
Because the
Lord,
crimes only fall within the jurisdiction of the court if they
yes,
are
in
classified
one sense
that
they're
way.
jurisdictional, but they're also substantive elements of the international crime. So, for example, murder, even a murder of a civilian, is not as such a crime in international law. Of course, it is in domestic law. So to elevate it to the status of an international crime, you have to have the chapeau requirements. Now, they may be satisfied, or they may not. It does require an analysis of the facts. And war crimes, for example, are committed only in an armed conflict.
I mean, if an individual just, so to speak, one-off decides to murder
Yeah.
the Home Secretary or whoever it may be,
Yeah.
I mean, that doesn't qualify as a crime against humanity or a war crime or anything else.
Exactly. So there are...
It's got to be in the context
Yeah.
of some wider,
Yeah.
whatever.
So,
enterprise.
I mean, if it helps to illustrate, obviously, from general knowledge, one knows of the atrocities of the Second World War. Obviously, there were the Nazi war crimes, which were the crimes committed against, for example, prisoners of war. Famously, the people fictionalized in The Great Escape, where 50 men were put in a field and machine gunned down. But then there are the crimes against civilians, when, for example, a wholesale population removal might take place in Eastern Europe to remove Jewish people or Slavic people to give the Germans Lebensraum. And that would be a crime against humanity, because it would be a widespread and systematic.
And so why isn't the mass bombing of Dresden a war crime? Perhaps it is.
Well, my lord, in this case, for
We don't
reasons
have
your
to
lordship
decide,
may
but I mean-
understand, I would be reluctant to answer that question. It's a question I've asked myself
I see,
many times.
I see.
It's,
And
it's a
what
di- it's a
happens
di-
if, I mean, a
it's
whole
difficult
boatload of Marines, go and make a secret landing somewhere, they're very much not dressed in their uniforms. They may be dressed in German uniforms, or they may be just in camouflage, or whatever it may be. I mean, is that a war crime?
Well, my lord, my understanding is that it wouldn't be, but
Wouldn't be?
That's my understanding.
Why is that?
I have to confess, I'm not the expert on international
I see.
criminal law, but what my lord rightly raises is that there can be some very difficult cases which seem contrary to first principle, and yet the answer also seems to be obviously against the answer that might follow logically.
But if you do it not in uniform, or dressed in German uniforms, you could be shot. I mean,
Yes,
you forfeited your status as
certainly the Second World War.
Yeah, I mean, you would have been shot. I mean, you can't. You've got to be in.
So it wouldn't be.
You've got to be proper uniform in order to get the status of
But there are
competent.
uniforms and uniforms. I mean, somebody going out on night exercises is not going
Yes.
to wear number one dress,
Yes.
which is going to draw attention
Yes.
to himself. And the commando's the same sort of thing too. isn't it?
No, but you mustn't be disguised as a
You
non-combatant.
can't go as a German. You can't go
No,
as a
but
German.
you can put up, you can blacken your face and wear a sort of
Yes.
a different type of headdress and a different kind of jacket
Yes.
and so on and so forth.
Yes, and my Lord is right. I mean, in the context of Iraq, I don't want to digress too much, but there have arisen situations of whether the Mahdi army, for example, are a combatant force, because they're not in conventional uniform, but they would argue, no doubt, that they do wear a certain kind of dress code, and there was only in such situations that they would go out to fight. Now, others might dispute that, but
Well, the long-range desert group in the Western Desert, they had a
Yes.
uniform of their own, which
Exactly.
wouldn't have been approved by the sergeant major and the guards, but it was suitable for what they were
Exactly,
doing.
exactly. And even in more recent conflicts, obviously battle dress has to be, to some extent, modified for the extrinsic conditions. My Lords, can I return to our printed case at this juncture, and particularly emphasise 4 paragraphs. Paragraph 50 to 52 deserve emphasis because we suggest that there is a need to be clear about what the particular joint criminal enterprise, which it is alleged has taken place, was. And I don't give the references again, but we've set out the footnote references there in the case law at the international level.
But I mean, with all the best will in the world, I mean, you know, if you're going to prosecute these people, of course you've got to do things, but we don't, that's not what we're doing here. We're not looking at whether this is a sound prosecution, whether this indictment is...
No, we'll accept that, of course, accept that. But there has to be more to it, and it goes into the fundamental trap that the tribunal in Gurung fell into, and the Secretary of State in this case fell into, which is that you just have sort of general list of various things that an organisation may or may not have done over a long period of time, with no attempt to focus on the particular individual who is said to be excluded. Now, I would respectfully suggest that it's not impossible to say, well, there was a massacre in the Katyn forest, and there is material which links you to that. That's certainly feasible, even at the level of executive decision-making. Secondly, I would submit that just because something may be difficult for the executive to do does not mean that it is not required as a matter of law. One remembers that the starting point is this is a convention with a humanitarian protection purpose. So one is not striving to exclude someone, but where you do have serious reasons for considering that a particular person, suppose after the Second World War, it really was somebody who was a member of the Nazi High Command. It was Goering or somebody like that, who comes to the UK and seeks asylum and assumed the Refugee Convention had then been enforced. It's designed to exclude such people. One accepts that. But if the evidence is scarce, if it's not entirely clear-cut what somebody's role was, it doesn't follow that you should then take the attitude, well, the executive has to be able to exclude people. It doesn't. Because the starting point is there's a fundamental right to the asylum, if otherwise you qualify under the convention.
But also, because I think the Commissioner makes the point that it's also, of course, undesirable to give refuge to people who should actually be tried for offences.
Absolutely, and one understands the rationale why 1FA was inserted in the first place. But all I'm saying is that it is an exclusion. The Commissioner, we're at one about this. They do say that because it's an exception to fundamental right, it should be construed narrowly.
I'm a little puzzled about whether they should be prosecuted or not. I mean,
yes.
I'm not sure whether the grant of asylum makes it any more difficult to prosecute.
No, it doesn't preclude prosecution. What it's designed to avoid is persecution. So just as our own citizens can be prosecuted.
I mean, I don't know. We got a extradition treaty with Sri Lanka.
I don't know off the top of my head. It may be that my learned junior can help. I don't know off the top of my head.
I
But in
was
principle...
wondering about that very point, if I might just interrupt. I mean,
You did.
if asylum is given, and assume there was an extradition treaty, that wouldn't prevent the treaty being operated, would it?
As long as... Well, it might prevent extradition if the grounds for non-refoulement still applied to that state. But perhaps more realistically, what it doesn't preclude, my lord, is either the exercise of jurisdiction in this country, if it has it,
Yes,
and,
of course.
and a number of heads of jurisdiction we would now have
Yes,
it,
for war
in
crimes.
particular if it was so serious as to be universal jurisdiction.
Yes. So
See
that could be exercised here. Then.
Yeah, exactly. So that's a very sound way, if I may say so, of reconciling the competing policy interests, which is that you give refuge to someone who qualifies, but if subsequently it emerges that there is in fact something that was a crime committed by this person, then you could prosecute them, because that can be done fairly and without persecution. I suppose another possibility, at least in principle, is that there might be a relevant international tribunal that could try someone.
And these are significant changes from the Nuremberg days,
Exactly.
where if you granted asylum, you'd be extracting the person from the jurisdiction
Yes.
where he could be
Yes.
prosecuted.
Absolutely, my lord. The international law and indeed practice has developed a great deal since 1945, and again I think it's common ground between us that one should interpret the Refugee Convention, including its exclusion clause, in the light of the state of international law at the moment of interpretation, and not when it was first drafted. My lords, I just wanted to emphasise the concluding part of this part of our printed case, which is at paragraph 58.
58.
58 and 59. I won't repeat those, but I wanted to emphasise those in
So,
particular.
what is the policy then of the behind the exclusion? How would you describe it?
Well, certainly when it was drafted, as I understand it from the UNHCR material that my lord has referred to, it was that refuge should not be available to those who themselves had participated in the persecution in the 1930s and 40s, particularly. That was one underlying thought. And the second was that because of the difficulties of prosecution for crimes, because there were jurisdictional problems at that time that are not so prevalent, at least now, that one was perhaps more willing to see that people should remain where they could be tried if they had committed crimes.
And nowadays, you sort of...
Well, now
the second one would be rather minor consideration.
It's been ameliorated in some of its force, at least. Perhaps I can put it that way.
I mean, it is rather a sort of puzzling concept because, I mean, theoretically what you're doing is you're saying to this person, well, other things being equal, of course, you need asylum in order to safeguard you against ex hypothesi persecution, which you shouldn't be facing abroad, but you're such a bad chap.
Yes.
You forfeited that right, and therefore we're going to send you back so that you can be persecuted.
Your Lordship is right to point to the conundrum. Obviously, in a different context, human rights law has developed in a completely different way.
Yeah, well, of course, if you happen to be a member of the Council of Europe, it doesn't much matter, except that, of course, asylum gives you a huge mass of additional benefits beyond merely not being able to be sent back.
Yes,
to
your Lordship is very alive to that, I know, and that's why it matters in practice to someone like my client. Discretionary leave, apart from being precarious inherently, doesn't give access to the full panoply of rights in the Refugee Convention. I think it's Article 7 to 33.
It's my fault, but what happens if somebody falls within the exception and it's applied? What happens to that person?
Well, I don't know the complete answer to that question. My own friend may be able to help, but taking this case as an illustration, as I understand it, what happens is that you go through a threefold exercise. You ask first whether they're a refugee under the Convention, and then the exclusion clause applies to that. If they're not, then the non-refoulement provision doesn't apply, nor do any of the other rights in the Refugee Convention.
The non-refoulement doesn't apply.
Yeah, that's right.
But they don't get... Is that because they're not counted as refugees?
Exactly.
Yes.
Yeah. So then you ask, do they nevertheless qualify for humanitarian protection? But in practice, the answer is going to be the same because the government's policy, and this is now also reflected in the EU directive and the regulations implementing it, has a very similar exclusion clause. We've seen that.
Is that 17 rather than there's 12?
Yes,
17.
indeed. Yes, indeed.
Yes.
Exactly, my lord. And then, as a residual, no doubt, safety net protect, the reason why we, as a matter of policy and discretion in this country, have the concept of discretionary leave is to cater for, I would apprehend, principally Article 3 cases, which of course is absolute. There's no bad person exception, if I can put it that way, to that absolute.
Bideh Shahal.
Exactly, you see Chahal. Now, it may not be relevant to the issues in this case, but my understanding is that until relatively recently, the practice of the Home Office used to be not to grant even discretionary leave in such cases. There was a concept of temporary admission. My Lord particularly will recall that from the Immigration Act 1971. And the question of law arose in a case in which I was engaged in the Court of Appeal, called S, but it concerned the so-called Afghan hijacking. And there, the issue of law was whether the Secretary of State had the vires to keep someone, as it were, on an indefinite basis, on renewable temporary admission. Suffice to say, the Court of Appeal concluded that there was no such vires. And my understanding, maybe wrong, is that it's partly because of that the practice has now developed of giving each such person who falls into the safety net category 6 months discretionary leave, which can then be renewed, but you review the circumstances at the end of that period. It doesn't give access to any kind of permanent residence, and it doesn't give access to the rights to work, social security, etc., in the Refugee Convention.
Thank you.
My Lords, Gurung is where I was going to go next,
Yes.
subject to the Court's wishes. That's to be found in Volume 1 at tab 11. We've dealt with it in writing at paragraph 63 to 67. Many of the passages have been referred to, and I'm grateful to my friend for that.
Sorry, your paragraphs?
Yeah, 63 to
63.
63 to 67, our printed
Sorry,
case
yes, sorry,
is our
sorry.
analysis in writing of Gurung.
Yeah.
May I just supplement that with these few observations? I want to go particularly to the two passages that I would respectfully agree with my Lord Hope, caused the most trouble to Lord Justice Toulson, and in our submission correctly caused trouble. They are paragraph 105 on page 24, and also paragraphs 111 to 113. In our respectful submission, the focus on the nature of the organisation at paragraph 105, even if one takes it, as my friend asks us to, with the quotation from paragraph 18 of UNHCR, doesn't solve the fundamental problem, because even that quotation begins to introduce concepts like acquiescence, rebuttable presumption of individual liability, immediately leading to a slippery slope, we submit, because rebuttable presumption there became presumption in our decision letter. And the problem, as Lord Justice Toulson said, is that the focus here is on the organisation and its methods and activities, predominantly terrorist in character. I have to say that even that phraseology is troubling, because as I was saying earlier to my Lord Hope, an organisation can be a terrorist organisation and proscribed as such on a number of lists, but that doesn't mean that the principles of criminal liability, personal culpability, joint criminal enterprise, mens rea, and all the rest of it that the ICC statute focuses attention on will necessarily be satisfied. It might be, depending on the facts, or it might not be.
I mean, as I understand it, Mr. Ike isn't relying on the limited brutal purpose,
No,
stroke predominant
Your
terrorism.
Lordship is absolutely right, and this is a
So,
fundamental...
I mean, paragraph 18 on the face of it doesn't apply, does it?
But the trouble is, my Lord, that Mr. Ike may not, but the Secretary of State's decision letter, paragraph 34, relied on Gurung expressly, relied, as I understand it, on this passage.
Well, it is actually the wording of paragraph 18, although it's taken through Gurung.
Yeah, and I have to say, with due respect to my learned friend, that however he puts it, and of course I understand why he puts it as an advocate that way, the problem for him is that his client didn't put it that way. And that's not a complaint, it's not a formalistic complaint about reasons, because of course reasons are there for a reason. Reasons are there so that a court, by way of judicial review and others, can actually detect whether a decision maker has exercised his functions according to law or not. And my lords, paragraphs 111 to 113 in Gurung are also troubling because of many of the reasons that have been adverted to, at least for the purpose of argument, by the court itself. The nature of the organisation, its purposes, whether its purpose is to set up an authoritarian government. Take, for example, a highly repressive organisation which only engages in traditional war fighting in uniforms.
Sorry, can you speak a little bit louder?
I'm sorry. So take, for example, an organisation which avowedly has an authoritarian purpose. It wishes to impose a highly repressive regime on a society by force of arms. Taliban spring to mind. They want to take over the government of a country or part of a country. They have completely anti-democratic views. What's that got to, if they engage in traditional warfare, wearing, for example, uniforms, however broadly that might be defined, it helps in no way to answer the question whether a member of that organisation has been a party to an international crime. To know that. And therein lies the danger again. Lord Justice Toulson, as your lordships will recall, suggested that this introduced slippery and subjective concepts. He didn't put it this way, but can I put it in my words? There is a danger that what is actually happening here is that 112 is the kind of organisations that we in the West might, in broad terms, tend to think of as good organisations.
ANC.
Yeah. So our natural friends, possibly, whereas people we don't like the Taliban, might well be regarded as being in 113. We suggest that the danger is that it takes the eye off the right ball, which is to ask whether there is, potentially at least, international criminal liability. Once you focus on the right question, you might get the same answer, or you might not.
The trouble is that paragraph, the UN document, paragraph 18, rather invites that approach.
It does, my Lord, it does. And Lord Justice Toulson did not shy from criticising the UNHCR in that respect, and we would respectfully endorse his criticism. Well, subject to the court's wishes, what I was proposing to turn to next is the Canadian cases. And just to locate them in our printed case, we've dealt with them in the printed case after we deal with the UK case law from paragraph 79 and following. There were three that my learned friend, I think, cited yesterday. May I briefly go back to those? The first was Ramirez, which is in volume 11, tab 86. 11, tab 86.
And do dates matter here? We're dealing with cases decided in the early 90s.
Yeah. One of the points I was going to make, my lord, the cases that were cited by my learned friend, can I just put it in a nutshell? We say, first of all, broadly, at the level of principle, they actually say things that are helpful to us and not adverse to us, although there are some dicta in Ramirez in particular, which I have to deal with about the limited brutal purpose. But secondly, I do make the observation my Lord has just put to me, that these were decided in about 1992, 1993, before the assistance which the Court of Appeal had from the ICTY jurisprudence, and of course before the drafting, in its final form at least, of the ICC statute, which was 1998. Now, in Ramirez at tab 86, much of it actually, we would submit, is consistent with my submissions, because it focuses on, my Lord mentioned the phrase yesterday, personal and knowing participation. So much of it actually is well rooted in traditional criminal principles, both of domestic and international law. I'll pass over the standard of proof point, which is at paragraph 5, and come back to it later in my submissions. But on the substantive principles, at paragraph 16, we see the point which is now common ground, that mere membership in an organisation which from time to time commits international offences is not normally sufficient. Then there's the quotation from Grahl-Madsen. But then this, and this is really the only passage I would suggest that is adverse to my submissions. And we submit it's both dicta, in other words, it's obiter, not essential to the decision in the case, and also is with respect wrong. It seems apparent, however, that where an organisation is principally directed to a limited brutal purpose, such as a secret police activity, mere membership may, by necessity, and it's particularly the phrase by necessity, which we quarrel with, involve personal and knowing participation in persecutorial acts. If the burden of that sentence is really on the word may, and it's doing no more than stating, as it were, a sort of common sense feature of human life, then it probably would be acceptable.
And if the word principally was solely?
Exactly.
Sorry, if the...
Well, principally, in the first line of that bit, if the organisation is solely directed to a limited brutal purpose, then it would be very easy, wouldn't it, to say yes.
One can very easily see in practice how it's going to operate then. But there are two difficulties for the Secretary of State in this. First is, as my learned friend has said, he does not, at this hearing, submit that this passage is relevant to the LTTE or the Intelligence Division.
I'm not sure I even understand what it...
Well,
Very odd sentence. What does it mean, such as a secret police activity?
I think what they had in mind was the Gestapo.
The Einsatz type of case
Yeah.
would fit it as well as anything.
I would agree, my lord. But that, as we've seen, arose in a very specific context in the particular circumstances of a particular statute at the end of the Second World War. But so my learned friend for the Secretary of State has the difficulty that he doesn't actually rely on this, and the rest of Ramirez is actually consistent, I submit, with my submissions. The second problem for him is
if supposing that I were a member of this organisation which is principally directed to a limited brutal purpose, and I've got the day off to go to my brother's wedding.
Yes.
When they go out and commit an atrocity.
Yes.
Does that mean does my membership, mere membership, mean that I'm guilty of that?
The logical implication of this sentence is yes, and therein lies the danger. If the answer is no, then one asks, well, what's the point of having this? What possible helpful guidance is this sentence providing anyway? Because if you still have to focus on the individual event and to what degree the individual person knew about things, intended things, then you're back to the right principles, I submit, and this passage takes you nowhere. The danger is that if it takes you anywhere, it's taking you down a very slippery path, which leads to somewhere which is wrong in law.
The reasoning of the paragraph, reading it as a whole, is that we'll look at what Grahl-Madsen says, And he has one particular end of the spectrum, as it were, and I know
Yes.
you say there are dangers in looking at it that way at all.
Yeah.
But having adopted that line, then you go to
Indeed.
the other end. And
Indeed.
that perhaps is an illustration of
Yes.
why the Court of Appeal were worried about the continuum approach.
Lord, I would respectfully agree with that suggestion.
I mean, it surely is a matter of absolute common sense. If you're a member of an organisation, all it's doing is terrorist, is wars against, etc.,
Yes.
crimes against, etc. Well, then, you know, that's a high probability that you're personally criminally responsible with everybody else in it. If it's, you know, just the very occasional bit of terrorism, well, then the opposite end of the spectrum. I mean, it's unhelpful to talk of continuum,
Yes.
not least because there are so many different factors variously pulling in different directions, and also because the Court of Appeal actually chose irrelevant considerations, you may say, such as the ultimate aim of the body in concern. But I mean, that's all really that's being said here, isn't it? These are just two ends of a spectrum. Neither is conclusive. Well, I mean, it is conclusive that it's not enough just to be a member.
Yeah.
You've got to have a bit more than that.
The trouble is that words like by necessity involve personal and knowing participation do invite the conclusion to be drawn that without more, the individual can be regarded as fulfilling the criteria of an international crime. Now, if all that's being said is that they may do, or they may not, depending on the facts, so be it. But the danger in formulating it this way, particularly the use of the words by necessity, is that it's elevating something, it seems, to some kind of presumption of law. And certainly the language of presumption then feeds itself into the English tribunal jurisprudence, which began to rely on this, and eventually finds its way into paragraph 34 of the decision letter in this case. And I said my learned friend has two difficulties. The second of his difficulties, of course, is that, however he puts it, the Secretary of State, in apparent echo, I know not, but in apparent echo of this passage, does focus on what it calls an extremist organisation. So the language has now become not only limited brutal purpose, not only principally directed, but on any view it's accepted that the LTTE has a variety of purposes, some of which are entirely legitimate in the international post-war context of decolonisation. And yet a concept that even on its own wording wouldn't apply to the LTTE is being apparently used, at least by the Secretary of State, if not his counsel, against my client in this case. As I said, my lords, much of it...
But he plainly wasn't doing it as simplistically as that. Otherwise, I mean, what's the point of most of the letter setting out the facts and his actual personal involvement? Why would the Secretary of State do that if he's just going down this bland road?
Well, I won't repeat, if I may say so, what I said earlier, but I do focus attention on the critical parts of the reasoning. The facts are set out as background facts, as often facts are, in a judgment, for example. But when it comes to the analysis of what is it that leads to personal criminal responsibility, paragraphs 31 to 36 are key, 34 and 35 are the principal paragraphs within that. Now, on the facts, of course, Ramirez was very different, and your lordship saw that yesterday, but can I just remind the court of paragraphs 37 and 38. We don't have the pagination, but it's towards the end, paragraphs 37 and 38. I won't repeat what was said there, that was looked at yesterday.
So he wasn't the conscript, as it were. He was, to some extent, although reluctant, he was a participant.
Yes, that's right, and he was present or aware of a large number of interrogations, for example. And he was on all occasions a participating and knowing member of a military force. One of his common objectives was the torture of prisoners to extract information. He was a part of the operation. His presence at a number of incidents of persecution, coupled with his sharing in the common purpose of the military forces, clearly constitutes complicity. So, On its facts, the case may well be correctly decided. It's not any part of my function to criticise the outcome, but the principles are largely consistent with our submissions. The one passage which is overturned is not relied on by the Secretary of State anyway, and we submit is wrong. Moreno I can deal with very briefly, I hope. It's in the same volume at tab 82. There was, in fact, in that case, a misdirection, as my learned friend accepted yesterday. So it was a bit like the Court of Appeal in our case. They actually said that the refugee tribunal in that case had misdirected itself in law as to the correct legal test.
So where's the misdirection?
The conclusion is really on the last page would allow the appeal. The last 2 pages at the bottom there, it denied the female appellant claim without first determining whether her husband met the inclusion criteria. This error, together with the board's erroneous finding that there are serious reasons for considering that the male appellant committed crimes against humanity, are sufficient grounds on which to allow the appeal.
Sorry, I haven't found that. We don't have
sorry.
page numbers in this case.
No, I don't think they have page numbers in this report or this transcript. There's the very last sheet,
Oh, I see.
which has
Yes.
the conclusion.
Yes. Right.
So in the result, the case was actually one which the applicant for asylum succeeded in, so it had to be remitted.
Yes.
And they asked the question, did the board err in law as to guilt by association and so on, from, I don't have the pagination, but it's...
How does the page begin?
Is it head F?
the page begins in the killing of civilians. It's a left-hand page.
Oh, yes, yes, thank you.
And your lordships will see that under guilt by association, it's well settled that mere membership, that's common ground. An exception to this general rule arises where the organisation is one whose very existence is premised on achieving political social ends by any means deemed necessary. Membership in a secret police force may be deemed sufficient grounds for invoking the exclusion clause. Well, that's the passage we've already seen from Ramirez, but isn't relied on in our case. I do emphasise the last sentence, that membership in a military organisation involved in armed conflict with guerrilla forces comes within the ambit of the general rule and not the exception. And that's the LTTE. I know, as my learned friend observed yesterday, that subsequent cases on their facts have said the LTTE does come within the brutal exception. But certainly we would submit that that can't possibly be right. And that's certainly not how the tribunals in this country have approached it. My Lord Brown will be very familiar with a number of cases at the tribunal level and in the Court of Appeal, where the LTTE has often been recognised as an organisation that in principle can give rise to someone claiming asylum successfully.
One of the routine grounds of asylum was that you're an ex-member and you're terrified of what's going to happen to you when you come back.
Absolutely. And I just emphasise that on facts that will be well known to this court, on the face of it, the LTTE would seem to fit squarely within the last sentence of that paragraph I've just read from.
Yes, I mean, I asked Mr. Eichhardt today, do you know of any case dealt with the intelligence division of the LTTE?
Can I, there may be one, when a junior is familiar with it. Can I just get the reference,
Yeah, yeah.
if it's available?
That's my fault.
We'll give the tap.
Why is
Can you just write it down?
an armed force? Why is it in conflict?
Can I just deal with the last of the Canadian cases, my lord? Which is Siva Kumar.
Yes, I'm quite sure.
No.
I'm not
Mr.
sure it
Singh,
really
sorry,
applies.
just this last
Sorry.
sentence. Why do you say it's
Oh.
that applies to the LTT?
Because, as I understand it, the LTT is accepted, at least as part of its activities, it's engaged in armed conflict with guerrilla forces.
No, it's using guerrilla forces rather than actually fighting them.
Who is
isn't
it fighting? Sorry, who are the guerrilla forces? I just didn't realise
Oh,
that.
forgive me. I've been reading this as in the sense of using guerrilla forces.
That's what I thought.
Yes.
Yes, because
Oh,
it
if
could
I've
be
misunderstood
read
that-
as actually
I'm-
fighting guerrilla
If
forces.
it means the people you're fighting against,
Yes.
then of course what I've said wouldn't be right.
Absolutely.
Yes.
Is that all right?
My Lord,
It's using gorilla.
Yes.
that's how I'd understood it.
Yeah, yeah.
That's how I'd understood
See,
it.
I beg your pardon.
No, forgive me if I've misunderstood it. There's a case where Immigration Judge Southern was the judge. We don't have a name for it, but it appears in volume 2 at tab 23 and was referred to, I'm reminded, by Lord Justice Toulson in our case.
Yes, it doesn't have a name.
And
but,
I think this may be one that my Lord Hope had in mind yesterday. Yes. According to the index, the name of the case is Sivanantharajan.
Oh,
So what's the name of it?
Sivanantharajan.
How do we know that?
But that should be anonymous.
Yes, it's been anonymised. That's why in the report, it's our fault. The index the joint parties have prepared has the name. Apologies for that. In the transcript, it's missing. Quite rightly, it's missing. And I'm reminded by my learned junior that Immigration Judge Southern set out the facts at paragraph 6 and 7. So it does deal with an appellant who was there working for LTT Intelligence.
yes. And what happened in this case?
Well, what they said was, significantly, that you had to look at the individual's participation. The particularly paragraph 36 on the penultimate page is helpful. Page 10, paragraph 36. So they understandably at the time, the tribunal directs itself in accordance with Gurung. But the flavour, if I could put it that way, of the approach is actually very different. Because at paragraph 36, your Lordship see that although it's clear that mere membership of an organisation will not be enough, the nature of the organisation may be that not very much more is required. Well, that was the guidance in Gurung. But here they say something more is required. And here it is said to be the fact that the appellant was, or would be on death, entitled to be recognised as holding the rank as major, and that he was serving in the intelligence wing of the LTTE. Now, at 38, they say that considering the position of the appellant, I reached the following conclusion. The exclusion is not established by a label or rank entitlement. It is necessary to look at what the appellant actually did and what his involvement with the LTTE was. And in the last few lines, as to the nature of the LTTE is regarded by the UK as a terrorist organisation, but it acts in the areas where it holds control as a de facto state with responsibilities for security. As such, it is to be expected that it should take steps to identify and remove spies in order to promote the safety of the civilian population it has accepted responsibility for. Yes. I'm reminded that Lord Toulson referred to this at paragraph 100.
100 of the Court of Appeal.
Yeah, Court of Appeal judgment in our case.
Yeah.
I'm grateful.
Ah, yes. He does name
Again, one sees the name of the case there.
Yeah.
Perhaps for safety's sake, one should anonymise that. My lords, I see the time.
Well, I wondered whether this was a point.
I don't think I need to go back to Siva Kumar unless the court wishes me to. And with that, I will have covered the Canadian cases.
Yes.
And so far as the law is concerned, I have a little bit more to say, in particular because I need to go back to the German cases.
Yes.
And then I shall have a little bit to say about the facts.
Right.
But I would hope to finish in the early afternoon, as I anticipated yesterday.
Well, that sounds fantastic.
And we should finish the hearing today, I think.
Well, we'll look forward to seeing you at 2 o'clock.
Thank you.